This meeting is being recorded.
Good morning. My name is Justice Barnes. I'm a judge in Ontario. Welcome to day 3 of the National Treatment and Therapeutic Court Conference. Before we go any further, I will ask Dan Bolton, who will do the land acknowledgement.
My pleasure, Your Honor. We will begin this event, the 2023 National Treatment and Therapeutic Courts Virtual Conference, by acknowledging that we are meeting on Aboriginal land that has been inhabited by Indigenous peoples from the beginning. As settlers, we're grateful for the opportunity to meet here, and we thank all the generations of people who have taken care of this land for thousands of years. Long before today, as we gather here, there have been Aboriginal peoples who have been the stewards of this place. In particular, we acknowledge the St. Thomas area, traditional territory of the Anishinaabe, Haudenosaunee, which is Iroquois, the Ojibwe and Chippewa peoples. This territory is covered by the Upper Canada Treaties. The Haudenosaunee, this name refers to the Iroquois Confederation comprising of these nations: Mohawk, Oneida, Onondaga, Cayuga, Seneca, and Tuscarora. The Anishinaabe name covers Ojibwe, Ottawa, Algonquin, Potawatomi, Nipissing, Mississaugas, Saulteaux, etc. of the Algonquin Ojibwa nations. These two names should be footnoted to include all the nations under them. We recognize and deeply appreciate their historic connection to this place. We also recognize the contributions of the Métis, Inuit, and other Indigenous peoples have made both in shaping and strengthening this community in particular, and our province and country as a whole. As settlers, this recognition of the contributions and historic importance of Indigenous peoples must also be clearly and overtly connected to our collective commitment to make the promise and challenge of truth and reconciliation real in our communities, and in particular to bring justice for murdered and missing Indigenous women and girls across our country. Thank you.
All right. Today we are fortunate to have Dan Bolton and Keisha Lewis as our hosts. And I'm going to stop sharing my screen and tell you a bit about our host for today. Dan Bolton, at 15 years old, Dan began to live homeless on the streets of Vancouver, Edmonton, and Toronto. He had an addiction to alcohol and opium. This trapped Dan on those streets for 8 years. Surviving violence, poisonings, and the deaths of close friends, Dan escaped the streets and made it back home to Owen Sound. At 23 years old, he got his grade 12 and grade 13. He ran Dan Bolton Drywall for several years until he was physically disabled by an impaired driver. Since that injury, some 29 years ago, Dan has been trying to return to the workforce. He studied business management at Georgian College in 1995. He earned a degree in psychology from the University of Western Ontario in 2001. Dan is currently a student in the paralegal program at Fanshawe College. He will be clean and sober for 30 years in total. And on June 5th, his sobriety came, on June 5th, he's 30 years sober, and his sobriety came in chunks. So he got 1 year, 8 years, 6 years, and then 6 years, in those kind of chunks. And sobriety and mental health did not come easily. There were meetings to attend, concepts to learn, and counselors to work with, survival against all odds. And Dan credits his family, friends, community. He specifically credits over 40 years of super counselors, doctors, teachers, pastors, and lawyers. So Dan is our first host with lived experience over the last 2 days. And then we have Keisha. Keisha Lewis is an attorney of law, educated in the United Kingdom. She's admitted to the bar of the Supreme Court Judicature of Trinidad and Tobago. She's been called to the bar for 5 years. Her practice is in the area of entertainment law, employment law, corporate and commercial, advanced civil litigation, and alternative dispute resolution. She holds a degree in Bachelor of Arts, Honors Business Management for Anglia Ruskin in London, England, a Bachelor of Laws from the University of London, London, England, a postgraduate diploma, legal practice, a Master of Laws, legal practice, family law from both Stratfordshire and Stoke-on-Trent, England. Currently, she's pursuing a postgraduate paralegal studies at Fanshawe, London, Ontario, and hopes to be admitted to the Law Society of Ontario in January 2024. She comes with a lot of experience, over 20 years of administrative experience, legal experience in oil and gas industry, and 10 years personal and commercial banking, accounting, and financial advice experience. Today, I'm not going to have a chance to take you through the agenda. I'm simply going to turn to our two hosts for today, Dawn and Keisha, to take us through the panel. And I hope you have a fabulous, fantastic conference. And thank you to all our presenters. So over to you. Who is going, Keisha or Dan?
Dan is going to go.
Okay. Okay, Dan, I think you're muted.
You're muted.
Hi, our conference starts today with the topic of bail, homelessness, addiction, and mental health. Topic close to all of our hearts, I'm sure. Wait a second. Her Worship Karen Ballantyne, Justice of the Peace from the Ontario Courts of Justice, will speak. Justice Ballantyne was appointed in March 2014. She presides over the Toronto region, where she interacts regularly with vulnerable individuals in busy criminal, bail, and case management courts. She brings an equity and inclusion lens to her various roles in the outside of the courtroom. She obtained a Bachelor of Laws from the University of Windsor in 2001 and was called to the Ontario Bar in 2002. She also has a Master of Laws with a specialization in criminal law and procedure from Osgoode Hall Law School. She is an AJ PO criminal law and procedure representative from the Advisory Committee on Education for the Justice of the Peace bench, and often mentors and assists with the training of her colleagues and other legal professionals. She has lectured at annual conferences of Justices of the Peace, the Ontario Bar Association, and the Criminal Lawyers Association on bail, case management, and cultural competence topics. Before her appointment, in addition to other roles in the community, she was the first elected African Canadian person to chair a school board in the Durham region, Ontario. I believe that we have Aspasia Pathadoro, Duty Counsel from Legal Aid Ontario also. Thank you.
Yes.
Thank you, and good morning, everyone. And thanks for inviting us to talk to you all about the substantive and practical issues that we often encounter in our busy bail courts, especially when we have vulnerable individuals seeking bail who may have mental illness, substance abuse and addictions, and who also face housing insecurity and homelessness. Aspasia and I are going to walk you through some of the issues that we frequently encounter in our courts by taking you through a scenario. And the scenario is as follows. Michael Tremblay was recently arrested and charged with theft under, assault, and failed to comply with a release order. It is alleged that he stole a bottle of alcohol from a liquor store and struck a loss prevention officer as he fled. He was already on a release for an arrest that occurred about 7 months ago for stealing alcohol from a different liquor store. A condition of that previous release order is that he not attend that particular liquor store. He is 26 years old, unemployed, and has no fixed address. He is originally from a small town in Nova Scotia where most of his family remain. He has a lengthy criminal record, is addicted to crack cocaine and alcohol, and may have an undiagnosed mental illness. The Crown is objecting to his release because they are insisting that he have a surety. Aspasia, can you please walk us through some of the substantive and practical issues that you might encounter when preparing for Mr. Tremblay's bail hearing?
Yes, of course. Good morning, everyone. So I'm just briefly going to say, for context, the situation that we are dealing with, our practice situation here, we're dealing with the current situation that we have now in the courts and the changes and constraints that the pandemic has brought to our court system. So things like all clients are going to appear by video from the division, so we don't get to see them in person once they're arrested. And I should also say that I'm going to be speaking from a Toronto perspective because that is where I practice and that is where I've always practiced. That's also where Her Worship practices. And a lot of the constraints that we will be discussing are certainly things that other jurisdictions are dealing with and may have been dealing with for much longer than us. I know in Toronto, prior to the pandemic, lots of clients were coming in person upon arrest and we get to see them. And that's not a situation that's always the case for outside communities outside of large cities. So in saying all of that, I will start from the moment of arrest. So we have Mr. Tremblay, he's been arrested. And I do know that he's dealing with some substance use issues. And so it's very often when you have clients who are dealing with both mental health and substance use disorder to get instructions on that first day of arrest. The client may be coming before you after arrest, not feeling the best. They may be dealing with symptoms of withdrawal. For clients who are dealing with mental health issues, if they may be dealing with active psychosis, depending on what drugs they're using, that could be exacerbated. So you have a situation where you have a client who is maybe not feeling well, and it's quite hard for them to provide instructions to you. It's further complicated by the fact that I don't get to see them in person. I'm not at the courthouse, they're not at the courthouse where I can tell the officers, can you just go to the cell and tell them they need to come talk to me. At the police division, it's extremely busy. Their resources are more stretched. There have been days recently where their video systems are not working. There are fewer rooms to interview clients. So if you have a large number of people who've been arrested and very limited space, let's say 2 rooms that they can be interviewed, and someone is not feeling well and tells the officer, I'm not coming, there is a chance you're not going to speak to that person that day. That is very problematic because in this case, Mr. Tremblay has a new charge. Yes, there is an assault resist arrest, and I would never minimize that sort of thing, but it is, the charge is stealing another bottle for someone who has an addiction issue. And because of the way the system is set up, I may not get instructions from them and that person may stay in custody for longer. That then creates other issues. Unfortunately, our access to clients at the jail has been limited a fair bit because of the pandemic. There are various ways that we can access clients. There are defense calls or video meetings that we can set up. However, those often get canceled. They often get rescheduled. Sometimes they'll be scheduled for 4 p.m. in the afternoon and you want the client to be back in bail court the next day. If you have an appointment with someone at 4 p.m. the next day, they're staying in custody for another day. So access to the clients has become a serious issue. And when a client is dealing with other issues as well, they're dealing with substance use disorder and they're dealing with mental health issues, they may not be able to advocate for themselves as much in the institution. There are duty counsel who are in the institution, but if you are in withdrawal and not feeling well or in a mental health crisis, your first thought is not going to be to ask to speak to a duty counsel at the jail. So the access to the clients then creates another barrier that is disproportionately it disproportionately negatively affects clients who are dealing with mental health and substance use disorder issues. The other issue is then it becomes very, very hard if part of our bail plan is to refer them to social workers and the social worker wants to speak to the client before. If they are now at the jail, it becomes very hard for the social workers to get access to them. It's hard enough for the defense lawyers too. The situation is compounded for social workers. In some cases, at some of our jails, we do have CAMH within the jail, so we can get access that way. But for the most part, it is very tough then to get access to the clients. Once I am able to speak to Mr. Tremblay, my next step is to get an idea of what his challenges are. So I do understand he's dealing with substance use disorder. He is dealing with homelessness, and there's possibly some mental health there. There may also be an acquired brain injury. So my job at that point is to find out from him, does he have community workers? Does he have a probation officer, any drop-ins or clinics or doctors that he sees, and getting permission to speak to those people, because he may not be in a position where he can recount his history to me because he's not doing well. But if he gives me permission to speak to those workers, then maybe I can get some of that information and then create a bail plan so that we can try to get him out of jail. If he doesn't have any of those supports in place, I then will speak to him about whether or not he's willing to work with community or court supports, and then refer him to the appropriate agencies. I'm sure anybody who works in this field will know that access to those resources was tough before the pandemic, but it's become really, really hard since. Shelter beds, there are fewer in the city. This is a man dealing with homelessness. It's going to be harder to get him a shelter bed. Shelters have lower capacity numbers now so that they can try to distance people. The hotel programs are being closed down. So there are less beds for clients who are dealing with homelessness. Detox beds have also shrunk. Especially for women in the city. We had one organization that had detox beds specifically for women, and they closed during the pandemic for renovations and haven't reopened. A couple of hospitals in the city do have detox beds, but if you're a woman who needs a detox bed in Toronto, it's really, really hard to get you one. So you have these resources that are basically stretched to the brink. You have mental health organizations in the city that are seeing much higher requests for their services, that are trying to assist everywhere they can, but they just don't have the resources to assist. So in this case, I will try to put together whatever plan I can. If he has his own workers, try to get those support letters. If he doesn't, make those referrals so that he can speak to the workers at the courthouse. Sometimes it does require to bring him into the courthouse so that he can speak with them and have access to those workers to get a plan together. Once that is done, and unfortunately that may take a few days. So again, the disproportionate impact for someone who is homeless and doesn't have any family who can sign a bail is that they may stay in custody longer before we deal with their bail. Once I have the plan together, I will at that point obviously speak with the Crown and try to negotiate a consent. We may need to run a bail hearing, but I will speak to them about some of the issues, and a lot of the Crowns will know some of the issues that we're dealing with, but discuss if he has an ABI, if he has community supports, what he's struggling with, various things. So the Crown in that case may actually consent to the release depending on the plan, specifically with respect to whatever context I can provide them and information I can provide them about my client. In some cases, this is something that we may raise during the bail. I know that Her Worship and other justices of the peace and judges don't often know about some of the things that are going on within the community and some of the constraints that we have. And sometimes, we will create a consent, for example, that has some creative conditions that may not on their face, it may not be obvious why we're asking for those things. So that's the kind of information that we might provide to the court to say, yes, we are having him not attend this specific address, but then there are other conditions, or whatever condition we may come up with, we may provide that context just so that Her Worship understands why we are proposing that, because there are a lot of things going on, and she may not be aware, for example, that we were told there are no detox beds, or the wait time at this mental health organization is 8 weeks, and that's why it can't be immediately put on the bail, but we've put that should the court or the Crown ask for proof, the client needs to provide it in the next few court appearances or something like that on the bail. So I'm going to turn it over to Her Worship so she can talk about the more legal side of what we're dealing with when we're dealing with a client like Mr. Tremblay.
Thank you. And in this particular scenario where the Crown is objecting to his release, specifically because he does not have a surety or someone to supervise him in the community, one of the first things that I want to canvass with the Crown directly is I'd be curious to know whether the Crown would have consented to Mr. Tremblay's release if he did propose a plan that included a surety. And I would ask the Crown this directly, just so that we may not necessarily have to go into a long hearing and just to kind of bifurcate or hone in on a focus hearing with respect to the form of release, particularly if I can elicit from the Crown that their only objection is not necessarily that Mr. Tremblay should be released or can be released in the community to await his trial, but that they would want a surety or a more restrictive or onerous form of release. And I appreciate that there are significant differences in the way that bail is adjudicated across the country. Ontario appears to be the only jurisdiction to primarily use justices of the peace to preside over bail hearings. And I think the Yukon uses a combination of justices of the peace and judges, and Manitoba, Nova Scotia, British Columbia only use judges in bail court. But the reason why I mention that is just because there's variations throughout the country, and where I preside in Toronto, where we have one of the busiest provincial court jurisdictions. We were extremely busy before the pandemic, as Aspasia had mentioned, but it's not uncommon now, post-pandemic in a virtual world, where we are seeing up to 50 individuals in our bail courts on a daily basis. And in Ontario, where our Justice of the Peace bench is a lay bench, although it includes lawyers, paralegals, former police officers, social workers, and other non-legally trained individuals or professionals, there are a number of issues collectively that we put our minds to. And so I just want to put that out there just because I know that in different regions, non-legally trained persons, as well as judges, are also doing bail. So for some reason, I will also note that police releases are becoming less frequent and many individuals are being held for bail, even though police do have the discretion to release someone with or without conditions from the division. And so that also kind of compounds or exacerbates the issues that we're seeing, because oftentimes those people who are held for a bail hearing do come from some of these vulnerable or have these vulnerabilities, as opposed to someone who may have someone to supervise them in the community, et cetera. And so when a person is held for bail or interim release, the general rule is that he or she should be granted a release pending their trial, unless the Crown can show cause as to why they should be detained. And an accused can only be justifiably detained on 3 reasons or 3 grounds. One is to ensure that they attend court. The other is to protect the public and to prevent the commission of a further criminal offense, as well as to maintain public confidence in the administration of justice. And I know some of you are lawyers, and so this might not sound new to you. However, my understanding is that there will be all kinds of individuals watching our presentation. And so requiring the Crown to show cause for detaining an accused person is consistent not only with the presumption of innocence, but also with the accused person's right to a reasonable bail under the Charter. And the right to a reasonable bail is also reinforced by the principle of restraint. And the principle of restraint has been recently, in the last couple of years, added to the Criminal Code, sections 493.1 and 493.2. That is that decision makers under Part 16 of the Criminal Code, police officers, justices, or judges, must give primary consideration to the release of the accused person at the earliest reasonable opportunity and on the least onerous conditions that are appropriate in the circumstances, including conditions that are reasonably practicable for the accused to comply with, while taking into account those grounds. Many of the accused persons who appear before me in bail court often have precarious housing, mental illness, or addictions. They become what I refer to as our frequent flyers or turnstile clients, because in addition to substantive charges, they may have accumulated several administration of justice offenses, such as failures to comply with court orders, while they're waiting to deal with their earlier substantive charges. These breaches now shift the onus to show cause why the individual should be detained from the Crown to the accused now having to show or demonstrate why they should be released, as is the case of Mr. Tremblay. Unfortunately, individuals like Mr. Tremblay are more likely to find themselves spending more time in pretrial custody awaiting the conclusion of their case than if they were to receive a custodial sentence. And I often take this into consideration, especially when I'm considering a criminal record, albeit a lengthy criminal record that includes dispositions with minimal to no custodial sentences. An accused person who's a member of a vulnerable population will often be unable to present, as Aspasia has mentioned, to present a conventional release plan that will include a surety. And so we are mindful then when we are presiding in these courts that the Supreme Court of Canada has acknowledged that courts have been relying very heavily on sureties as part of a release plan, which can not only be onerous as a requirement, but it may not even be necessary. And oftentimes when dealing with accused persons with mental illness, addiction, substance abuses, and precarious or no housing, I'm tasked to consider the merits of an unconventional release plan. In the case of Mr. Tremblay, he has no family in Ontario, does not appear to have anyone who can supervise him in the community. He's unemployed. He may have a few meaningful relationships with other persons, or his relationship with the community support agencies may not be fully established. So when I consider these types of cases, I try to be mindful of these challenges and limitations that vulnerable accused persons live with. If I'm being asked to consider a community agency that I'm unfamiliar with as part of the plan, I will ask about the availability and quality of the support that the agency is able to provide, because the existence of supportive relationships can contribute substantially to mitigate the risk of post-release offending behavior. The more information about the available supports and the benefits that the support provider may have, when we have that information, it gives us a better position to be able to evaluate the merits of the release plan and to ensure that any interim release order that is made takes into account the particular circumstances of the accused, as well as the challenges that he or she might face. Ultimately, I think that each interim release hearing involves consideration of a community organization, such as bail program or community mental health, for example, gives us as judicial officers an opportunity to better understand the local environment and available resources. And again, as Aspasia has pointed out, the lack thereof post-pandemic. And one of the challenges that I often see is that persons like Mr. Tremblay, who may be in and out of the system, finds that sometimes they become ineligible or disqualified from participation in these programs by virtue of their alleged breaches. This means that I may be asked to sometimes release an individual on a bail that is less onerous than the previous release that they were once on. And I will say that I appreciate the limitations that duty counsel and private counsel faces under the current regime when it comes to bail. However, I would still encourage counsel to provide very detailed information, if they have that information, about the operations and resources of community organizations that are expected to support vulnerable accused clients if he or she is ordered to be released from custody. But it also gives us an opportunity to learn about the resources that are available within the community that we may not be aware of. So this is a perfect segue for me to talk about section 493.2 of the Criminal Code, because as part of the principle of restraint that we must consider when deciding whether or not to grant a release, the court must also give particular attention to the circumstances of A, Indigenous accused persons, and B, accused persons who belong to a vulnerable population that is overrepresented in the criminal justice system and that is disadvantaged in obtaining release under Part 16 of the Criminal Code. This remedial provision has been added to the Criminal Code a few years ago now with the passing of the Omnibus Bill C-75. Police officers, justices, and judges must put their mind to the systemic issues of the overrepresentation of these vulnerable populations in the criminal justice system generally, and in the remand population specifically. There is often overlap and intersectionality of more than one particular vulnerability. For example, a person can be Indigenous or Black and also have mental illness and have unstable housing. They would be captured by section 493.2 because of the disproportionate representation they comprise in the criminal justice system. The second part of this criteria is that these particular vulnerable groups have been disadvantaged in obtaining an interim release, maybe for the reasons I've stated previously and the reasons that Aspasia has stated, and maybe for other reasons. So a judicial officer, myself included, when I'm deciding whether to grant interim release, I must be alive to the issues of overrepresentation. And I ask myself regularly whether or not the decision to deny someone bail is perpetuating the systemic problem of the overrepresentation of this particular group. Similar to how we treat youth contested bail hearings, I think we must always consider whether any reasonably practicable conditions or combinations thereof can mitigate the risk based on the statutory just cause grounds for detention. In the case of Mr. Tremblay, I'm reminded of Regina and Morales, which is a Supreme Court of Canada decision, which states that bail is not denied for all individuals who pose a risk of committing an offense or interfering with the administration of justice. Bail is denied only for those who pose a substantial likelihood of committing an offense or interfering with the administration of justice, and only where that substantial likelihood endangers the protection or safety of the public. Moreover, detention is justified only when it is necessary for public safety. So similar to Section 28.1 of the Youth Criminal Justice Act, I take the approach that a vulnerable person should not be detained in custody or be released on conditions for social welfare purposes. If all of the circumstances, including the proposed plan of release, leads me to find that Mr. Tremblay has not shown cause why he should be released due to his membership in a vulnerable population disadvantaged in obtaining a release, I next ask myself in my decision to detain Mr. Tremblay, if my decision to detain Mr. Tremblay is based on some sort of bias, known or unknown to me, that I might have against the vulnerable group that he is a member of, or even the nature of the charges before me, or maybe because of how he presented or behaved in court, all of which may be impacted by his illness or other vulnerabilities. What if Mr. Tremblay was particularly abusive in court or difficult to manage? This section of the code necessitates a lot of self-reflection by judicial officers in this regard. I would encourage judicial officers to look at some of the anti-bias bench cards or checklists that can assist with the types of questions to ask yourself when deciding whether or not to grant an interim release under Part 16 of the code. Also, as a decision maker under Part 16 of the code, I may not know about an accused person's vulnerabilities if it is not obvious or disclosed to me at the hearing. I have now incorporated as part of my practice in court to ask at the start of a hearing whether Section 493.2 applies and how it applies. This usually alerts counsel to submit evidence or information so that I can make a proper assessment under this section. I am mindful that when inquiring about the personal circumstances of an accused, that I elicit only the information that is necessary to meaningfully evaluate the proposed release plan. My advice is that the limits to this inquiry about the personal circumstances of an accused, as identified by counsel or even the accused person himself, should be respected, because discussing private life in a public forum can be stigmatizing and also traumatizing. So the takeaway from my discussion is that making decisions about the interim release for accused persons with mental illness and addictions, in addition to poverty and isolation, can be very challenging, and so can crafting realistic release orders. So I'm going to just mention the case of Zora, which is a leading authority. It's Regina and Zora. And we're required to consider, when making determinations with respect to interim release of vulnerable persons, whether or not the plan addresses some of these issues. So the court has observed that when we prosecute a number of individuals for failing to comply with conditions of an undertaking or release order as it relates to vulnerable persons, it often involves questionable release conditions that are imposed upon them. So the court states that the principle of restraint requires that any condition of bail be clearly articulated, minimal in number, necessary, reasonable, and the least onerous in the circumstances, and sufficiently linked to the accused risk regarding the statutory grounds for detention. The principle requires everyone, especially judicial officers, to scrutinize bail conditions at the release stage, whether bail is contested or on consent. Release conditions should be tailored to the unique circumstances of the accused in order to address those risks, and they are supposed to be imposed with restraint, not only because they result in the limitations of liberty of persons presumed to be innocent, but also because they often criminalize what would otherwise be considered to be lawful behavior. A couple of those conditions, and Aspasia, I'm sure you've made lots of submissions with respect to these conditions. One, conditions that directly address symptoms of addiction. So for example, alcohol or drug abstinence conditions, which we no longer impose, but the odd time we may be asked to do so, but it's most Crowns don't even make those submissions to me because they know where I stand with respect to those conditions. Conditions that are designed to encourage rehabilitative behavior, for instance, counseling and or treatment conditions, are only appropriate if they are sufficiently related to the accused risks. But again, we use those very sparingly, and I should say I use them very sparingly. The condition to keep the peace and be of good behavior is not a required bail condition, so I never impose that condition. And conditions that delegate the discretion of sureties or others to establish bail rules effectively bypass judicial scrutiny, and they should be avoided. And so those are conditions such as follow the routine and discipline of the address. Unfortunately, I've seen sureties pull bails because an accused person on a release order did not throw out the garbage, and that was a condition that they imposed separate and apart from the bail conditions enumerated in the release order. And so I'm mindful of those particular issues, and especially as they are conflated with respect to vulnerable persons. And I do see Aspasia nodding because I'm sure that she encounters that often in our bail courts. So one of the things that I will say with respect now, turning to the situation of Mr. Tremblay that we've discussed, is that in this scenario, because he's facing additional new charges of theft under, fail to comply with a release order, and assault, if the Crown's only concern is that his release plan includes supervision by a surety and he does not have one, if I'm satisfied that an unconventional release plan sufficiently mitigates against the risk to reoffend in public safety, I would grant his release without a surety. So I'm going to now just turn to Aspasia because we've been having really good discussions since we started preparing for our presentation. And one of the questions one of the discussions that we had involved Aspasia telling me, about her appearance in drug treatment court and Gladue court. And I wanted to know specifically if you can share with us what's that like if you're appearing on bail matters, or have you noticed any differences in how bail is treated in a therapeutic court versus a regular bail court?
Yeah, certainly. So there is a difference. With respect to drug treatment courts, our drug treatment court does require a guilty plea to take charges in. In that case, there's usually a guilty plea, but then there's a bail to deal with afterward. The mental health court clients often are coming back from treatment orders, and we will deal with the bail if the client is fit. In many cases, not all, there are some cases where that's not going to work out because of the seriousness of the charges. But let's say it was someone like Mr. Tremblay coming back into the mental health court, then certainly that's a bail that we would try to negotiate and deal with in the mental health court. And in Gladue, we do run contested bail hearings, but it is a different situation. And the greatest benefit with respect to the specialty courts and to therapeutic courts is that everybody involved there on that team has specialized training and is familiar with the issues that we're dealing with. So we have, for example, in our mental health court, we have a concurrent disorders worker. We also do have social workers that are attached to the court, who are fully aware and more aware than we are of what it's like on the ground and what resources are currently available and what's not available. You also have crowns and judges and justices, well, it's judges in these courts, but crowns and judges who know the same things, and they've dealt with these issues. And in the case, for example, of drug treatment court, the judge has a lot of information about the client. So if, for example, the client we knew had an acquired brain injury, we're going to be very careful about the conditions that we put on that release and how we explain them to the client. And we're going to strive to create a bail that is something that is not setting the client up to fail, taking into account the very specific issues that they are dealing with. There's also additional resources in those courts, resources that are underfunded, as I'm sure everybody here will know, but we do have our treatment partner for our drug treatment court is CAMH, which does have a lot of resources, which is very helpful. We partner with Aboriginal Legal Services and our Indigenous Persons Courts. And our mental health courts, there are various agencies that assist, but at Old City Hall, it's Fred Victor, an agency there. And so you have all of these workers. We have caseworkers and court workers who will attend from Aboriginal Legal Services to our Indigenous Persons Court, but they also have an organization behind them that has other workers. They have FASD workers, they have other workers that they can, and resources that they can refer clients to and come up with a plan that, while it may not have, you know, that surety supervision that the Crown and Mr. Tremblay's case is looking for, does have increased support in the community and resources that specifically would assist a client like Mr. Tremblay. In drug treatment court, all of the clients have their own therapist, and they have the other resources that we have a probation officer who works with us. So if the client is on probation, they can also assist. It's that specialized knowledge. There are specific psychiatrists who come and work with our mental health court who could assess clients for a diversion. For a matter like this, this is certainly something that we would speak to the Crown about, maybe getting this, you know, toward that path. And if the Crown is saying, yeah, this is something that's divertible, then why wouldn't they agree to a bail? So that's the sort of thing that is the difference with those specialty courts, is everybody gets it, everybody knows what's going on, and everybody is, it's, you know, the justice system is an adversarial system, but the great benefit and what I really appreciate about working in the therapeutic courts is that everybody is working as a team, and everybody understands what a blunt instrument the justice system is for people who are dealing with substance use and mental health issues.
Thank you. And I think we may have some questions. I'm going to turn it over to Keisha, perhaps.
Oh, looks like we do.
Yeah. You're muted. I know that you, there we go.
I just came off. Thank you. Thank you, Justice Valentine. So I just have one question in the chat, and it's from user Melva. In thinking of the scenario presented for Mr. Tremblay, what is the relationship like between duty counsel and the treatment and programs department in correctional facilities? I've also typed it in. Oh, sorry.
Sorry, go ahead.
I was just gonna let Justice Valentine know I put it in the chat as well.
Oh, okay.
In case it was read too quickly.
That's fine. Thank you.
So with respect to that question, we don't deal much, at least as a duty counsel who works in the courthouse, we don't deal much with treatment and programs at correctional. I know that we do have institutional duty counsel, at least in Toronto. So there are duty counsel, there are for, you know, the big jail, the Toronto South Detention Center, there are 2 duty counsel who are permanently assigned there, and then other duty counsel who assist. With respect to some of the changes the pandemic has brought, for a very long time, over 2 years, we did not have duty counsel in the jail. They would just receive calls in the morning from the clients. And so when you're not actually physically there, you then start playing phone tag. So I know that those duty counsel who are within the institution, there's, like I said, 2 of them, and there's 1 on any given day now because of the pandemic. I know that they do have relationships with some of the staff at the jails, the social workers, the various people who are on site. So I know that sometimes they do help us facilitate things. But for the most part, as a duty counsel at the courthouse, it's impossible to get a hold of anybody who might be able to assist. Like I said, we do have CAMH there at the jail, and that has been very helpful. That started before the pandemic, but certainly within the pandemic, sometimes that was the only social worker I could ever get a hold of at the facility. With respect to the jail for women, it's the Vanier Institution here for us in Toronto. I've had slightly more luck getting a hold of a social worker, but still it's a lot of phone tag or email tag. And if you're trying to ensure that someone who you think might be in crisis needs to be seen and they're not being seen, it's really hard to play email tag or phone tag for days when you know someone is suffering and doesn't need to be. So it's been tough, and it's gotten worse because of the pandemic. So us getting access to clients at the jail and getting access to workers who might be at the jail.
So can I just add to that? Because one of the things that I've been doing is requesting that individuals be brought into the courthouse on their next appearance so that they can have an opportunity to see duty counsel. I know now that everyone is returning back to in-person appearances. That includes all of the crowns and duty counsel, whether it's on a rotation basis or on a full-time basis. But by bringing individuals into the courthouse, I think it's an attempt to try to alleviate some of those concerns so that they can see, for example, a mental health worker or even duty counsel. I can tell you that in bail hearings, they're now conducted similar to this fashion by Zoom, where sometimes a division or a jail or an institution does not have access to a video camera. And so they're putting individuals on the telephone who are only hearing voices. They can't discern who the Crown is, who duty counsel or private counsel is, and even who the justice presiding is. And so although we're identifying themselves, you can only imagine when someone's in crisis, how that might appear to be for them, and who's speaking and who to trust, et cetera. And so there are a lot of issues that I notice when I'm presiding in a bail court, and I'm always astute to those issues. And so even on the most busiest days, I try to make allowances to have, for example, an accused person speak to counsel in a breakout room, for example. Obviously there's limitations as to how much time I can give, but these are a lot of the issues that we're trying to address with respect to, access, and so that, good bail plans can be put together. And we're aware, and I don't want to speak for everybody else, but I do think that the bench is astute to and live to those issues as well, right?
Yeah, and that's certainly something that that we have been doing more, is asking for clients to come in person. I think, especially for a client you might think is in crisis, it is important to actually see the client and for them to see you. The first almost year of the pandemic, everything was done by the phone.
Yeah.
I don't know why you would trust that, especially if you're someone who is accustomed to the way the justice system works and you're in crisis and suddenly it's just voices and you're being told it's because of the pandemic. I don't know. I mean, I might think that they were lying to me too. So it's one of those things that has been a serious problem. And yes, we will ask if it's become a serious issue, and a couple of days have gone by, then we'll ask for the client to be brought in person. And I know they don't like it, and I don't really care.
Yeah. And I know that we're almost done, but there is something that I do want to add, because with the inclusion of section 493.2 in the criminal code, when we talk about vulnerabilities and just putting our minds to that before we decide to detain somebody who is captured by this particular section, I often hear submissions, and I don't mean to pick on the Crown because we don't have a Crown on our panel, but I often hear submissions by the Crown that, well, this person has upteen amount of releases, therefore, they haven't, they're not prejudiced in the way of securing a release order, so section 493.2 doesn't apply. Well, that doesn't abrogate their membership in that particular group. And so we often hear that. And so when we're dealing with vulnerable persons, we have to think about the impact of our decisions, whether or not to release or to detain, and the impact that it has systemically overall on the criminal justice system. So yes, with respect to bail and dealing with particular individuals with vulnerabilities around housing insecurity and mental illness and addiction, there's a larger systemic problem that we always have to keep a finger on the pulse to. And that's the hope that, and I do see that we're moving in that direction with respect to always being live to those particular issues and how it does impact the system. So,
Sorry, Your Worship, I could ask us a question. I work with the homeless population, people experiencing homelessness in St. Thomas, and for 5 years, and we've came up with kind of the same ideas you guys have come up with in the courts for housing, is that it needs to be a non-traditional approach, something different. You used the words unconventional release if somebody didn't have a surety, if they're a member of this vulnerable group, qualified for the special needs of your that unconventional release. We call it non-traditional housing that we're asking for. It seems that the thinking is the same, and it's beautiful to see. And I really thank you for doing it. If you just knew how important it was to continue that view of how critical these people are and how much they need the system's help, and how you guys are the answer. And sometimes we're also the problem along the way, but that's what this is about. Courage to improve today's conference, and you've certainly showed us some wonderful examples of that.
thank you. Thank you. And in all fairness, with the scenario that we raised, one of the reasons why we raised that particular scenario is because we often encounter the request to impose a surety on someone where it's not necessary to address the concerns, right? And so, and not just requiring a surety, but requiring a residential surety, and that's, you know, compounds the problem even more. And so, I appreciate, you know, that different areas are doing different things, and these are opportunities for us to all learn from each other. So thank you so much for your comments, Dan.
It's funny you say that. Twice in the last year, I was asked by a local lawyer if I could be a surety, and I couldn't do residential surety with my friends. It just wouldn't work. But I could do non-residential and stuff, but they're not ready for that yet around St. Thomas. But soon, we hope, you know, the growing concern and realization of these people's actual lot in life and severity of their criticalness. It's coming to light, and just thank you so much.
Thank you.
And I think that's why it's very important, and I also think that's why things in the specialty courts tend to work better, because everybody does know about those things, and everybody understands the context and the situation that that clients and what they're facing when they're in a situation where they don't have stable housing and they're dealing with concurrent disorders. So
thank you. And Aspasia, I have a compliment for you by Melva, a suggestion based on Duty Council Aspasia's presentation. It would be great to have presentations as this done to an entire treatment and programs group so that individuals understand the impact as presented and assist accordingly. Relationships do make significant differences. Great job in the presentation. Thank you.
thank you.
Okay. And I think our time is up. Thank you very much, everyone, for having us. And feel free to reach out anytime to me as well if you have any questions. Obviously, I have limitations as to how I can assist, but that's what we're here for. So thank you.
Same here. I'm happy to speak to anyone about any of these issues, or I know we spoke about bail in general, but treatment courts as well.
Thank you. Bye, everyone. Have a good day. Enjoy the rest of the conference.
Hey, thanks a lot. Bye.
Okay, it looks like when we will have to make some adjustments in terms of the interpretation. Nicholas, good to see you. So Dan and Keisha, I'll leave it up to you to introduce our next panel and move on. It looks like we're going to do consecutive interpretation instead of simultaneous, but you guys are pros. I'm sure you can handle it. So I'll leave it to you guys to take it from here.
Thank you, Justice.
Can we turn the recording off, Your Honor?
Yes, you can, and I'll do that. Just a moment. Okay.
Welcome back, everybody. I would like to introduce our panel for this next event, named the Youth Therapeutic Court Program, regarding the general principles guiding the structure and implementation of some youth programs are discussed by an experienced legal practitioner. I do believe that is Miriam Henry, Crown Counsel for the Crown Law Office, Ministry Attorney General. Ms. Henry is an assistant Crown attorney who has dedicated her career to supporting better outcomes for justice-involved youth. She is one of the Ministry Attorney General's leading experts on youth criminal justice and has over 2 decades of prosecutorial experience, much of it as Crown team lead at 311 Jarvis. She is currently the Crown lead at the Toronto Northwest Justice Centre, where she was instrumental in envisioning and implementing a new and innovative community youth court premised on the co-location and integrated service delivery of justice, education, health, and social services in partnership with community. Her significant contributions to youth justice have been widely acknowledged, and she is a recipient of the Ontario Bar Association Criminal Award of Excellence for Innovation in Youth Criminal Justice, the Zenith Award for Women Advancing in Law, and the OCAA Rupert Ross Award for Excellence in and Commitment to Social Justice. We also have Mike Brooks, Senior Policy and Program Coordinator, Manager at the Justice Centres, Ministry of the Attorney General. Mr. Brooks serves as Manager of Justice Centres at the Ontario Ministry of the Attorney General's Criminal Law Division. In his role, he works with partners from across sectors and provides expert advice on innovative crime reduction and criminal justice initiatives. Welcome.
Good morning. Thanks so much.
Good morning. We're just going to be sharing our screen, so just bear with us for a moment. While that's happening, I'll just indicate that we're very pleased to be here today. We are here to discuss the Toronto Northwest Justice Centre. The Justice Centre is a new court model in Ontario, and it is focused on youth at this time. So I'm going to turn it over to Mike to discuss the Toronto Northwest Justice Centre and justice centres in general.
Lovely. Thanks so much, Miriam. Okay, I think it makes sense to start with the basics. If you're not familiar with the Justice Centre model, it is actually not a new concept. It's actually a model that's in use in over 70 jurisdictions right around the world. It is driven by various levels of government and even police services in some instances. Really at its core, a Justice Centre, or you'll hear us call it a JC, combines 2 main ingredients. And the first ingredient are elements of a specialty court. So you can think of a adult therapeutic court, a drug treatment court, or a mental health court. That's ingredient 1, combined with elements of a community hub. So think of a space that co-locates various wraparound services, health, education, housing, the list goes on. Critically, justice centers are not diversion courts, and in fact, they can have an impact at multiple points in the criminal justice system. That can be pre-charge, post-charge, and even post-conviction as well. In Ontario, we've tuned that justice center model so it makes sense in the communities that it's currently operating. And importantly, community itself remains at the heart of the design, development, and operation of all justice centers. This is really driven from the bottom up. As a provincial ministry in Ontario, part of our job is to help rally some of the resources and relationships inside of government, including the ministries of health, education, and social services as well. It really is a wraparound approach. When we began this work in Ontario, we knew it would be critical to develop a long-term vision for justice centers. And that's what you see on your screen right now. It's that building. We're not quite at this stage yet, but at full scale, justice centers serve 3 distinct populations, which are in the middle of the slide. The first population are individuals who have been charged by the police and are in need of assistance as they go through the court process. Another group are individuals who have come into contact with the police, but have not been charged. They're at the pre-charge stage. And then finally, in the middle there, you see we've illustrated community members. And those are individuals who have not come in contact with the criminal justice system, but indeed may still be in need of some help and supports. So here's a really concrete example. In this long-term vision, you can think of a building that has in the same space, probation officers, a legal clinic to support landlord-tenant issues, as well as dedicated community case managers from community-based service providers that could help people complete high school diplomas, connect them with clinicians like social workers and psychiatrists, and do some harm reduction work as well. So that is kind of that's the place we'd like to get to here in Ontario. So what's happening right now? Well, right now there are happily 4 justice centers that are up and running here in the province. There are 2 in Toronto. We'll be zoning in on the Toronto Northwest Justice Center today, but we also have one in the Downtown East community of Toronto, one in London, and then one in Kenora as well. And you'll see on the screen, each of them not only has a distinct focus population, but it actually is a unique expression of the Justice Center model itself. And again, driven by community. So briefly, in London, the Justice Center is focused on young adults aged 18 through 24 who are disconnected from school and work at the same time and are looking to reconnect with those systems of support. In the Toronto Downtown East, the focus is on adult chronic offenders who are at the intersection of housing instability, homelessness, mental health challenges, and addictions challenges as well. And in Kenora, the focus is really on addressing the overrepresentation of Indigenous youth and young adults in the criminal justice system. And a huge part of that is working with Indigenous service providers, existing restorative justice programming, and Indigenous leadership as well. So each has a unique focus. We'll use the balance of our time today to zone in on the Toronto Northwest Justice Center and to walk us through some of the core elements of that particular JC. Miriam, I'll pass it over to you.
Thanks, Mike. The reason you're looking at this map right now is one of the things we want to highlight is that the Toronto Northwest Justice Center has a jurisdiction that's very, very large. There are 6 police divisions that feed into our Justice Center. And if you look at this map, it is north of Steeles, east of the DVP, west of the 427, and 22 Division goes all the way down to the lakefront. And so why is this important to consider? Because there are many, many communities within this large geographic range. And what we have done is take a look at who are the people in these communities. So you'll see on the next slide that what we did is do a deep dive to see what is the experience of the people and the many different communities in that large geographic path. And when we look, there's some things that we've learned. We've learned there are significant issues with community violence. And what we know about community violence is community violence leads to significant trauma. We know that in these particular neighborhoods, there is extreme gun violence, and gun violence not only traumatizes those who are directly involved, but the communities and where those bullets flew. One thing we know is that COVID did not impact this level of gun violence. That remained unabated. We took a look at who lives there, not just what are the dynamics in the communities, but who are there. And we know that it's varied. There's a high population of racialized people, people who identify as Black, new immigrants, people who have been in community for generations. But there are some very significant experiences in terms of systemic factors, in terms of inadequate housing, inadequate access to healthcare, to mental health supports, over-representation in criminal justice, over-contact with the police, systemic factors of racism. And so when we look at that and we're trying to figure out how do we include, how do we address, how do we operationalize the YCJA? How do we take young people who have this background and try to change their circumstances? So we looked at the type of offenses they commit. We looked at the system itself and some of the structures in that system that might be barriers. So what we have done is we decided to create a court model that addresses the issues that the young person has. Not necessarily their charges, because the social factors around them often are part of the reason they're in conflict with the law. So in order to operationalize the YCJA, you need to understand who you're dealing with. Because if you're going to try to rehabilitate somebody and reintegrate somebody, you need to understand who you're dealing with. And what we know from our research is we have a high level of population who have lack of access to resources, while significant systemic trauma related to racism and other issues related to poverty. Every young person who comes into the Justice Center has a community counselor, has a case management counselor. And that counselor does an intake interview with them. And that interview was created through a joint effort of specialists in community, people with lived experience. We all came together and how do we best capture the experiences of the young people who come into conflict and who are in our Justice Center. And so there are a number of domains, and we look at things like, do you have an adult that you trust? Have you been a victim of violence? Because one of the things that we're trying to do is break the cycle of violence. So we find out what is happening in that young person's life, their education status, what's going on. And then we have two different things that happen. We have in-house supports where we have brought supports to young people that are part of the Justice Center. We have a dedicated psychiatrist. So if we have a young person who's in immediate crisis, we can instantly connect them with a psychiatrist. We can also have medication assessments, risk assessments, academic assessments. We also have a dedicated social worker who can do immediate counseling for young people if they've been flagged as of needing an immediate intervention. We also have an education advocate. That person is a lawyer who is assigned to kids who flag with education issues. We know in terms of preventing cycles of violence and improving outcomes for youth, education and maintaining your education is a key factor. We know that a lot of racialized youth are disconnected from their education. We know that a lot of youth who are in conflict with the law end up disconnected from their education. So that lawyer gets assigned to young people who flag with those concerns. And the beauty of this court model is that we have protected and preserved your right to trial, that you can assert your charter rights. You can determine that you want to have a trial and also access these services. So you can come into our court, have the caseworker do a full intake and access our services. That intake also, and the beauty is we've connected to pre-existing community organizations and services that have been in community for many, many years and supporting many different types of community members and different people from different cultural backgrounds and racial backgrounds, but they have never been part of the traditional referral pathways in criminal justice. And we have embedded them into our referral pathways. So a young person gets an individual plan that will include accessing our in-house supports and referrals to community partners who can help with other identified issues. That young person can then take that plan and go and have a trial, and yet still access those resources. Or that young person can stay in the Justice Center and be case managed by our dedicated judges and be supported throughout the process while they work through their plan. We look at trying to prevent people from having to be in the system in terms of a probation order if it's not necessary, and we can upfront the work that would otherwise be done on a probation. We do that. We're very mindful to do things quickly. We know that young people should not be before the courts and going in and out of a courtroom constantly is not good for identity. So we try to rapidly have the criminal matter dealt with, but the supports the young people have and the plans and the referrals in community, those remain because the issues we identify remain longer than the charges. And we want to make sure that those people are continued to be supported so that they don't come back into criminal justice. One of the ways we do this is that we also provide referrals for the family. You can't help a young person if the whole family is in crisis. You have to help the whole family as well. If a young person is going to resolve at the Justice Center and there's not going to be a trial, then we reach out to youthful victims who've been a victim of violence and to provide them with the supports they need so that they don't then become an accused and come into the criminal justice system. So part of our process is about identifying who the young person is and what their needs are, and then addressing those needs with rapid intervention and supports. We recognize that there are a number of issues that our young people deal with. We have also gone to help develop the Mary Donne program, which is a specific program for Black youth and Black identity, looking at issues of identity and self-esteem. We recognize that there were some gaps in service for community members, and we were trying to fill those gaps. So every young person leaves the Justice Center with an aftercare plan. And if they are found guilty by the court, we build in a sentence review, because we're looking at record retention issues, and we want to review that sentence again and offer supports for young people if need be. Moving on to the next slide, what we've done is we have embedded this in communities. So we have the Toronto Police in agreement with the police that when they arrest a young person, they release them directly to one of two locations. One of them is at 1126 Finch Avenue West, where there are service providers at that location known as Luminous, and there are many different mental health and addiction service providers there, or they're released to 21 Panorama Court, again, with all sorts of service providers there. So they can access court through a video suite, have their case manager meet them there, and then after court access services. What you see in the middle is that all of those judicial actors, the judge, everybody else is remote. Our long-term vision is a dedicated space that Mike was talking about, where we bring in all of the supports to young people so that they can come into the Justice Center and immediately access supports so that they can quickly obtain the services that they need to address the factors that brought them into criminal justice. And moving on to the last slide, I'll turn this over to Mike in terms of our outcomes.
Yeah, so we've been up and running for nearly 2 years now, not quite. It's a little bit early for a really robust recidivism analysis, but that doesn't mean we have some, we don't have any good feedback to share. We do have an evaluation structure in place for all of the Justice Centers in Ontario, and it does focus on quantitative and qualitative measures. I'll start with the quantitative, and that's at the bottom of the slide. We're really proud that every single participant that comes into the Justice Center receives some type of support that's been informed by the intake interview and really navigated by that case management role that we spoke about. Everybody gets something, nobody is missed. And it really is an understatement to say that it's just a case management team, because really there's a broad range of service providers, in fact, over 50, to which we have referral pathways. And those agencies are focused on health, education, employment, family services. The list is very, very long. Many of those service providers in that list of 50 are multi-service providers, meaning you can go to them, to one agency and receive a range of supports under one roof. And finally, we're really proud of the final data point you see, that final bullet. Over half of the young people that have an identified education need leave the Justice Center after their court matter has concluded, having moved the needle on their education need. That is a really, really hard thing to do. Often getting someone re-enrolled in school or dealing with an expulsion or an exclusion is not something that happens overnight. So Justice Centers exists in this middle ground of trying to move people efficiently and responsibly through the court process, and at the same time, giving them enough support so they can make those big changes. And really we're really proud of that final bullet. And it really is all toward that dedicated education advocate who's a trained lawyer, but has a very niche focused practice on the Education Act and helps people get to where they need to be. We also have some qualitative feedback as well, and that's in the middle of your screen. These are just two examples, but we've received some feedback from defense counsel who are bringing multiple clients to the Justice Center, participants themselves, but other family members, brothers, sisters, moms, and dads, and of course, service providers that are seeing these young people outside the confines of the justice system. So just a bit of a sampling there as well. We really hope that we get to report back later when we have some more robust quantitative information. Hopefully on the justice side, we're a little bit shy of that line quite yet. Miriam, anything to add to the outcome side?
The only thing I would add is that we're always improving. This is a process that's ongoing, because every time we get feedback and we tweak what we're doing. If there is anybody listening to this presentation whose work overlaps with what we do, that you see that there's an intersection, please reach out to us. We would be very happy to meet with you and discuss. We're always looking to broaden our referral pathways. We're always looking to partner with other organizations, because part of what we need to do is link all the different organizations, ministries, everybody who's working essentially with the same populations, and bring our resources together for comprehensive approach to young people. And so the Justice Center is something that does that. And if there's any of you out there that can see that your work intersects with ours, please reach out to us. We would be more than interested in hearing what you're doing and seeing if we can embed the work of other professionals in what we're doing.
I'd like to.
A moment or two for questions.
I just have one question that's in the chat. Is there a YMHCW involved in the JC team? Is that the social worker you mentioned?
We have a number of social workers. We have 2 that are case management intake. We also work with Psych Media, which is our psychiatrist, and he hires also psychologists and social workers that work with him. So we actually have a number of different social workers in the Justice Center in different ways.
Thank you.
Mr. Brooks and Ms. Henry, I'd like to thank you very much for a very holistic and a bit of a breath of fresh air, all of the areas that you cover, including your success in noticing people flourishing through education. It was huge for my own healing. It is a step in the right direction that we just love to take in healing. And I thank you for the work that you're doing. You're talking about aftercare plans. That's huge because transitions are critical. And your justice centers are a beautiful picture. And I love the ideas. Thank you very much for coming today. We're going to move on now to the Toronto Mental Health Court. Oh, sorry.
Hi. Sorry, I just had one question that came in again, just to the panel. What is the role of the youth mental health court worker?
The youth mental health court worker is in the traditional courts. We have our own in-house staff, as we've talked about, but the court workers are still play a vital role assisting young people who are in the traditional court. We have, as you've heard, our own in-house specialists that can assist young people and assist them when they are appearing in mental health court, in the traditional court, in terms of providing any background materials or assessments that could help any mental health worker trying to advocate for their client. So we do intersect because, of course, we're dealing with the same population, and we don't keep all of our cases. Some of those kids want to have trials and then end up being supported by other workers in the courthouse, but they can always rely on the materials that have been provided to them through the Justice Center and the supports they have at the Justice Center to improve their outcomes in other domains, not just in our court, but in other courts as well.
Thank you so much.
Thank you.
Thank you. Thank you for your courage. I'd like to welcome Daniel Brandes from the Crown Attorney's Office to discuss the Toronto Mental Health Court. The why and how and impacts of the Toronto Mental Health Court shall be discussed, including challenges, successes, and best practice recommendations. Welcome, Daniel.
Thank you so much. I just want to make sure that everyone can hear me okay. My technology sometimes is problematic, so does it sound all right?
Sounds good.
Okay, great. I feel very fortunate to be here today. I've been the dedicated Crown in the mental health court at Old City Hall since about the midpoint of 2018. And was able to preside there, have been presiding there over some very challenging times during COVID when everything shut down and we went virtual. But maybe what I'll do is just describe for you what the bulk of our work is in the mental health court. So it's one of the only dedicated mental health courts in the criminal justice system in the country, as far as I'm aware. It's one of the very few. And the bulk of our work relates to cases involving fitness to stand trial. So people who've been charged with criminal offenses, who are laboring under significant mental health disturbances that interfere with their ability to meaningfully participate in the criminal process. Those cases come into the mental health court at Old City Hall, which is now in 102 Court, but soon will be very different as we move into the new Toronto courthouse, the amalgamated court at 10 Armory Street. But when those cases do come into our court, we have the good fortune of having forensic psychiatrists who attend on a daily basis to conduct assessments. So they assess people who are thought to be unfit to stand trial, and the mechanism by which those people are assessed involves the issuance of a Form 48. And the Form 48 gives the authority to the forensic psychiatrist to assess an accused person to determine their fitness. And those psychiatrists who come on a daily basis then are in a position to provide evidence on a viva voce basis. So they come and take the witness stand, they testify in court about the assessment. And in the event that a person is found unfit to stand trial, the Crown often applies for a treatment order. And the treatment order is an extraordinary remedy that's provided for in the criminal code. The treatment order is essentially forced treatment. And the aim, of course, is to bring the accused person back to a state of fitness so that they can appreciate the nature and consequences of the proceedings themselves and participate in them meaningfully. So that's the one of the primary objectives of 102 Court, the mental health court, is to assist people who are unfit to stand trial and coming back to a state of fitness through these extraordinary sections that the criminal code provides in part 20.1. The other very significant part of our work is the diversion program, the mental health diversion program. And that's really, I think, one of the most gratifying areas of the work that the mental health court does. So basically you have a significant number of people who've been charged with criminal offenses who come into this court, and it's been identified that there's a nexus between their mental health condition and the alleged offenses that they're charged with. There's an understanding too, that the level of moral culpability is significantly diminished for people who are not only facing or laboring under significant diagnoses, but also people who are facing other challenges, other concurrent disorders, substance use issues, insecure housing, homelessness. So a very large group of people come into 102 Court for the purposes of working towards the diversion of their charges. And we're blessed in that court to have other care providers and service providers connected to us. So for now in 102 Court, we have the Fred Victor Mental Health Court program. And we have a whole roster of wonderful court workers who meet with the people who are doing the diversion work and basically act as the quarterbacks for their rehabilitative programs, their counseling, connecting them with housing services. I think everybody who is involved in this panel and is taking part in this conference appreciates that there is a very significant lack of resources in the community right now, in all areas, whether it comes to issues of shelter, medical services. So it's been a very, very challenging time, particularly over the COVID period, over the pandemic. I'm hoping that conditions are going to start to improve. But we're also looking at a very significant change to 102 Court because Old City Hall is being shut down at the end of May. And all of these services, this court is basically being transposed into the new courthouse. My understanding is courtrooms 806 and 807 are going to be the designated mental health courts at the new Toronto courthouse. And the model for the court at the moment, I think should be the same. I think that's the plan, but it remains to be seen whether or not we'll continue to have the benefit of the dedicated and specialized crowns and judges who preside in that court. And I say that because there's, I think it's been well recognized and understood that the consistency of having the same people in the court who get to know the clients, and I'd rather refer to them as clients rather than accused, but you know, having the same people who get to know them, develop relationships, and that kind of continuity goes a long way towards not only establishing but promoting the therapeutic benefits and effects that this diversion program offers to people. And I think one of the hallmarks of the mental health court, particularly when it comes to the diversion work that we do, is that it's a much less adversarial process. The goal is not to seek sort of what the fit punishment might be, but rather to come up with a plan for each person who's going through diversion to assist them in addressing the underlying issues that led to their charges. I mean, invariably, it relates to a mental health problem, but that's always just one of the issues that these people are dealing with. And so the beauty of the diversion program in the mental health court is that it allows for sort of a multifaceted approach. We're not just dealing with one issue; we're dealing with all kinds of challenges that the clients are facing, and the court workers and the various organizations that are connected to them work very hard to assist the clients in addressing those underlying issues. And then the ultimate goal at the end of the diversion is for those issues to be addressed as much as they can, for the client to sort of avoid any further charges, achieve stability in the community, and then ultimately the Crown has the ability, once that has been achieved, to withdraw the charges that have been laid or to ask the court to stay the charges. And that's sort of the ultimate goal of diversion, is to see people getting to a better place, to a place where they're not as likely to come into conflict with the justice system, and to have their charges either stayed or withdrawn. And it's been a very gratifying experience working in that court for the last few years. Progress is rarely linear. Oftentimes we see people who do well for a period of time and then sort of fall off or fall away. But the beauty of the court that we've tried to sort of foster is to sort of keep the door open and ensure that there's an appreciation for the fact that people have ups and downs, and we try as much as we can to give people wide latitude, appreciating the lack of resources that exist in the community. So that's sort of the nature of the work that we do in the dedicated mental health court. My sincere hope is that the tenor and character of the court is going to be maintained as we move into this brave new world of the amalgamated court. And it remains to be seen what effect this amalgamation is going to have. I anticipate it's going to increase our numbers significantly. I'm hoping that the resources that are going to be available will also increase significantly, but that remains to be seen. In terms of best practices, I guess what I would suggest, and this is for any of the defense counsel who are with us, and even any of the other service providers, whether it's mental health workers or housing workers in the community, or anyone else associated. I think what I would encourage is for there to be as much communication as possible between the various stakeholders involved in that court. Sort of the open flow of communication and the appreciation that this is a less adversarial system, I think allows for the best outcomes. I think also ensuring that people come in person. I mean, we have the Zoom capabilities and the Zoom platform available to us, but having that face-to-face connection, sort of the intimacy of being together in the same room, I think also goes a long way to increasing the sort of benefits, the therapeutic effect, so to speak, of the interactions that we have. So I'm happy to answer any questions if anyone has them, but that's sort of the nuts and bolts of what we do in the mental health court, and I'd be happy to answer any questions. I can see that some are coming up.
Mr. Brandeis, I'll let Keisha check for any questions, but your comment that about intimacy of being together being an important factor, it goes back to, I think, all of our understanding and belief at this point that relationships are key, that all this healing and all this change and everything comes through relationship. I got to the point where I'm thinking that there isn't anything out there that's valuable and helpful unless it is coming through human to human contact. Human relationships is everything for us human beings. And I can tell you from healing and being helped and rescued by professionals like yourself, it's those relationships. They just mean so much. And so that intimacy you're talking about is precious. Thank you for getting that right.
Thanks, Mr. Bolden.
I do have one question and two comments. So I'll do the question first. So who are the members of the mental health court team? Does that include the court workers in the diversion program, and are the court workers paid?
Yeah, absolutely. So the members of the team really include the judiciary, the Crown, duty counsel most often, lots of private counsel who are sort of have specializations in the area and come often to the court. But integral, absolutely integral to the team are the mental health court workers. At the moment, it's the Fred Victor Mental Health Court program that's working in 102. But I know as we move into the new courthouse, there will be other organizations like the CMHA, CODA, all kinds of other organizations who are going to come together and try and work together to continue in this sort of, especially with the diversion program. And then we also have the benefit of CAMH being connected with us as well. And they have a contract with our court and sort of a memorandum of understanding. And they're the ones who provide not only the forensic psychiatrists who conduct the fitness assessments, but also they have doctors who come twice a week to our court to interview people, meet with people, and assess them to see their suitability for the diversion program. So they get referrals from all kinds of different courts for individuals to come and be assessed. So it's a multidisciplinary group, multifaceted, and everybody's sort of integral to the process.
Thank you. I do have another question that came in. Does this court serve youth also? And what is the criteria for being eligible for this court? Are certain offenses excluded?
Yeah, excellent question. So I've never, in my 5 years working in the court, I have yet to deal with a youth matter. And that's I think that's, I just actually received an email about that from a colleague recently asking about what facilities are available to assess young people with respect to fitness. I would imagine that the court, 102 court, the mental health court, is flexible enough to be able, in rare circumstances, to address youth matters, but generally speaking, we don't. It's been adults almost entirely since I've been there. What was the other part of the question? I apologize. I know there was another element to the question. The criteria for eligibility for diversion. I think that was it.
Right.
Right.
Yes.
So there are certain charges that are presumptively not eligible for diversion. And the Crown policy directive sort of outlines them. But in a nutshell, driving offenses for the most part are not eligible. Offenses involving significant bodily harm are not eligible. Usually domestic violence charges are not eligible. So in essence, the more serious matters, the more serious charges are presumptively not eligible for diversion. But it's important to recognize that the door is not absolutely closed. There's certain circumstances, rare circumstances, where even significant charges can be considered for diversion if the factors suggest that it's appropriate in the circumstances. And oftentimes we reach out to complainants, we reach out to police officers, we reach out to members of the community to get input. Where in those rare circumstances where those presumptively ineligible charges are being considered, it's important, certainly for the Crown, to get input from the various stakeholders involved in that particular case. So usually the people involved in the diversion program are people who've been charged with offenses that are on the spectrum, not as serious.
Thank you for answering. So I have 2 comments based on your presentation. So it's so important to deal with multiple issues because research tells us that mental health issues are generally not the key or proximal factor or risk factors for offending. It is also so important that we retain dedicated judges and other team members who have specialized training and experience thinking of the model or process that will be rolled out in the new courthouse. So those are the comments, and you were thanked profusely in the chat for your presentation.
I'd like to thank you too, Mr. Brandes. You're mentioning, I have one comment. I think it's very positive. You're mentioning your partnership with CAMH. It was 40 years ago that I was on the streets of Toronto, and I did have to go to the old City Hall courthouse a couple of times, and didn't always get there when I was supposed to and stuff like that. And the only help that I ever got out on the streets during my 8 years in Toronto was a CAMH, a blind counselor. And it was called Addiction Research Foundation back then. And they're our top addiction and mental health research hospital in Canada. And I just want to honor the work that they did with me in the past and that they're still doing with you. So thank you very much. If we could bring in the next group, then if I could introduce them. They're from the St. John Mental Health Court in New Brunswick. I'd like to introduce Judge Andrew Palmer from the Provincial Court of New Brunswick. His Honor Palmer graduated from the University of New Brunswick Law School in Fredericton, New Brunswick in May 1990 and was admitted to the Law Society of New Brunswick in June 1991. He practiced law in St. John, New Brunswick and Sussex, New Brunswick, maintaining a general practice from June 1991 until August 2014, when Judge Palmer was appointed to the Provincial Court of New Brunswick, sitting in St. John. In the fall of 2017, upon the announcement that there would be a specific docket in St. John Provincial Court to allow individuals who encounter the criminal justice system while dealing with mental health issues to be diverted from regular court proceedings, Judge Palmer assumed primary judicial responsibility for the operation of the St. John Mental Health Court. In addition to fulfilling the usual duties as a provincial court judge, he has continued to preside over the court to the present. Thank you, sir. And with you today, we have Crown Attorney Natasha Meyer and Crown Attorney Ms. Logan, both from Public Prosecutions in New Brunswick. Thank you for being here.
All right. Thank you very much. Can you hear me okay?
Yes, sir.
All right. So again, my name is Andrew Palmer. I'm the judge assigned to the mental health court here in St. John. And I and you have the benefit of having Ms. Logan, Rebecca Logan, and Ms. Natasha Meyer present with me today to speak to you about the St. John Mental Health Court. As Dan indicated, it was in the fall of 2017 that the provincial government announced that there'd be a specific docket assigned to the St. John Provincial Court with respect to mental health court. It was a second iteration of the mental health court in St. John, the first having been established by Judge Alfred Breen as a pilot project in 2000. And then it became a permanently established in St. John in 2003, and Judge Breen continued to maintain it until his retirement in 2010. After that, there wasn't much judicial interest in maintaining the docket, and it fell by the wayside until the province, I believe, recognized the benefit of the mental health court and reestablished it in 2017. Basically, and I don't want to prolong the talking more than is necessary, but basically what the court does is it recognizes that there are individuals that come into contact with the criminal justice system as a result of either an unaddressed or underaddressed mental health issue that caused or contributed to the commission of an offense. If that's recognized by one of the court participants, then they may make a referral to the mental health court, at which time we undertake an analysis to determine whether or not they would qualify. Essentially, there are three criteria that are required for mental health court. It's first, that there has to be a mental health issue that is connected to the commission of the offense, and there also has to be an acceptance responsibility of the commission, although not necessarily be it a guilty plea, but just an acknowledgement that that they did commit the offense that is alleged. Presently, our team consists of myself as a judge, Ms. Logan and Ms. Meyer as the primary Crown Counsel assigned to the mental health court. We have a dedicated duty counsel, dedicated social worker and nurse, as well as a dedicated probation officer. And we meet bi-weekly to discuss matters that are occurring in our court. Previously, we had the benefit of a psychiatrist, that was assigned to the court, but he's on sabbatical and I don't expect that he'll be coming back, and he hasn't been replaced. And also we've lost the benefit of having a clinical coordinator who was integral in coordinating our efforts with community partners and ensuring that the needs that were seen within our clients were sought to be addressed within the community. That in a nutshell is the mental health court, but the nuts and bolts of it are going to be addressed by Ms. Meyer and Ms. Logan.
So in our mental health court, there's basically kind of three different parts to it. So I'm going to talk about the first part, which is the referral and eligibility. New Brunswick is a little different than some of the other provinces because we're what we'd call a Crown approval province. So a Crown prosecutor reviews every charge before it gets laid by the police, and we basically run through our assessment of whether there's a reasonable prospect of conviction, and then if there is, if it's in the public interest to proceed with that charge. So there's a lot of vetting that happens there. And a big part of that process as well is what we're seeing is Crowns in our office are identifying people very early who pass those two thresholds, but who may qualify for mental health court, and they'll write it right on the file. Those files would then go into our plea court, which we call current court. And so those people would be identified at a very early stage as being a possible candidate, and if they wish to come over to the court. And so that's done by a Crown. Other than that, we accept referrals basically from anybody. A lot of times it's duty counsel and speaking with the clients, identifying potential candidates, and sometimes it's coming from the judges themselves. And it can happen at any stage of the proceeding prior to sentencing. We have had people come over when it's the day of their trial, and these issues have arisen and they would like to be referred over. Sometimes it happens at the bail stage or first appearance. So there's really no set route that one needs to take. There are multiple opportunities to come over and then be assessed for mental health court. In our mental health court, you don't have to come with a mental health diagnosis. It's certainly helpful to us, especially now that we don't have a psychiatrist on the team, but it's not required. And we work to help people get that information. And as Judge Palmer said, there needs to be an ability to take some sort of responsibility, even if it's not with a guilty plea. So those would be kind of the main things we would be thinking about in terms of eligibility and people being referred over.
So I'm going to go through the next two parts, which is the assessment phase for an individual who has been referred over to mental health court, and then what we work through in looking through those individuals and that assessment that's been done to determine whether they are eligible to participate. So because individuals can come over without a diagnosis, that's kind of our first look at these individuals. We have participants who come over sign consents at their very first appearance in mental health court. That gives us the ability to have social workers look through any past mental health files that they have. So if they've had past interactions with the mental health clinic or anything like that. And as well as justice to look into past files as well. So for the assessment portion, a social worker meets with all of the participants and does an initial intake. So looking through if there is that history, trying to look if there has been a diagnosis. And then when we did have a forensic psychiatrist that we had at the table, all the participants would also meet with a psychiatrist to formalize a diagnosis and also to look at the topic of medication and whether that's required or not. Where we don't currently have a psychiatrist on our team, we have one made available to us for situations where we really feel like it's necessary, but the social worker really does a lot of the heavy lifting right now in terms of looking at what information there is out there and going through the current symptoms and issues an individual is facing. So outside of looking at the confirmation of any mental health diagnosis, another thing that happens at the assessment phase from the Crown side is looking at the charges that are coming over with the potential participant and determining a Crown's position on those charges. So if it's a situation where jail is absolutely necessary, we can't get around it, or there's a mandatory minimum or there's something at play, then at that point in time, the Crown will voice their opinion that this doesn't look like it's appropriate, even though someone may have a mental health issue. Also look at compliance issues. So those are in cases where perhaps somebody does have a pretty lengthy history with mental health. Are those individuals actively participating in the treatment that they're already a part of, or are people chasing them for compliance, things like that. So if someone, as I'm sure everyone's aware, mental health court, being a therapeutic court, requires a lot more participation from individuals. So we want to make sure that people are on board and will actually engage. Once the assessment phase is complete, the whole team gets together. So Judge Palmer, the Crown, Duty Counsel, the social worker, probation officer, we'd have a roundtable discussion where we all kind of talk openly about what we think about those eligibility criteria. Is there, number one, is there a mental health issue? Number two, is there that nexus between the mental health issue and the offense? There are, I should say too, in terms of eligibility criteria, when we're all talking, there are most disorders are included and we would consider for participation. And we also consider concurrent disorders. So if there's addictions as well as another, a mood disorder, schizophrenia, something like that. If it's purely addiction, unfortunately, we're not set up to deal with just that. We just don't have the resources here to do that. But concurrent, certainly we do. And some personality disorders are accepted. That's a case-by-case basis. And again, that comes down to resources. So once the disorder meets the criteria, the nexus meets, the individual is willing to take responsibility, then we determine this person looks like they're a good fit, and then they'll continue on into the program phase as long as they also want to participate. So that takes us into the treatment/monitoring phase of the program.
So I'll speak briefly about that. That's kind of the final phase of our program. And generally what we do when people are accepted to the mental health court is Rebecca and I would draw up in consultation with the team and duty council kind of a contract. We call it a contract of expectations for the clients who are coming to mental health court, so they know upfront exactly what we're hoping to see them do and what kind of progress we're looking for. And included in that would be the Crown's position. So if you do kind of XYZ and it goes well, this is what the Crown would seek at the end of the process. So that can be anything from a withdrawal of charges to peace bonds to discharges, anything non-custodial essentially. And so the treatment plans that we have are different for every person. They're really tailored to the issues that the clients are facing. Sometimes it's a harm reduction model of reducing their substance use in coordination with going to counseling. Sometimes it's including detox. We had someone recently who completed some domestic violence specific counseling. So we really try to meet people where they are and address their specific needs and make that part of the contract that works for them. Generally, we meet as a court every 2 weeks. So we try to use the appearances kind of as a carrot and a stick. So if you're someone who's not really complying very well and things are falling off the rails, well, then you'll likely be coming to see us every 2 weeks until we can make sure you're engaging with your services and doing what you're supposed to do. If you're really doing well in the community and you're doing the expectations, then you can come back in many, many weeks, sometimes months. We try to be flexible with people who are in school and working. So we do try to accommodate the clients as best we can. In terms of length of time with the program, it really does depend on the person. Sometimes it's a very narrow issue. Often it might just be a medication issue. So we just want to see a period of stability for that person. And once they're back to being stable and they kind of have their resources lined back up again, they can be finished with the court. But in general, we're often staying with people for a year to 18 months, and then hopefully having kind of a graduation for them at the end. In terms of the role of victim, we're trying to get, if there is going to be a requirement for a guilty plea, we're trying to get that early in the process so that we can get victim impact statements. They can be read if they wish to come and engage with the court. And then we can kind of move forward as a benefit to the client of mental health court too, not having to discuss the facts at the end when they've done so well in the process. So that's kind of how our program phase works.
In terms of, I know we don't have a whole lot of time left, so I'll try to be brief. Similar to what Daniel indicated from the Toronto court, in terms of best practices, it's critical really to engage your community partners. Unfortunately, we're at a bit of a disadvantage right now with the court because it's been a period of time since we've had really a dedicated clinical coordinator that would coordinate issues between the court and community partners to make sure that our clients are receiving services in the community that they need in order to recover from whatever the issue is that they're presently addressing. And we really miss it. So it's critical that there be that communication between the court and the community partners. The other thing too is, even though we've lost a clinical coordinator, we continue to have members of the team that are fully engaged and committed to the clients and the purposes of the mental health court. It's very rare that you see that there is someone that just doesn't fit within that parameter, but when it does happen, it's glaringly obvious. And like I said, we're fortunate that we have in the past and we continue to have in the past, including Natasha and Rebecca, fully engaged and committed partners to trying to achieve the best possible result for our clients. And I'm glad to say also it's necessary that you work together as a team. There's no one voice that supersedes anyone else, and you work collaboratively, and everyone's input is valued and sought after, and as many voices as possible that can be heard around the table are sought to be achieved. So that in a nutshell, I don't know if there's anything else you would identify, but
No, I don't think so.
That in a nutshell is what I see as from our perspective at least, what's necessary in order to make a successful model. Anyway, I know there isn't a whole lot of time, but we're certainly prepared to address any questions that anyone may have.
I'm not sure if Keisha will find a couple questions there or not, but I can tell you that it's really heartening, and I have the greatest hopes for your continuation of your wonderful court. Natasha, Rebecca, in your honor, thank you for coming today and for all the work you've done. I know that in St. Thomas, we cycle through different people being around and the core. And quite often the core is a smaller group like you guys, but it's that core that does all the work from the beginning to the end. And in the future, you guys are going to still be there. And because you have that core, this is going to continue and all them people are going to get help. So don't worry about those extras. They'll all come. Just keep it going because it's life-saving and it's beautiful to see. And thank you for the encouragement of being here.
All right. Well, thank you for your comments.
Thank you. Judge Palmer and prosecutors Rebecca and Natasha, there's one question here in the chat. So where there's a concurrent disorder of substance abuse, does the contract of expectations require urine screens?
Yes.
Yeah, quite frequently, yes. So and when we know that there is a concurrent issue with respect to drug use and the mental health issue, we'll get a urine screen very early in the process, and they will be screened regularly. And it's set out in the contract of expectations, and it's set out to them very early. This is what we expect you to do. And we know you're not going to be able to address it immediately overnight, but we want you to try to address it to minimize the risk and continue to address it going forward. So, and they know, our clients know that if they may be periodically subject to providing a urine screen on their appearance in court.
Thank you, Judge Palmer.
Thank you.
Thank you very much. I guess I'm going to move on to the London Adult Therapeutic Court. Crown Attorney Yee, Charles Yee, Assistant Crown Attorney from London Adult Therapeutic Court, Ministry Attorney General, is here with us. His biography, his bio. Crown Yee has been Assistant Crown Attorney with the London Crown Attorney's Office for the past 18 years. He is the lead prosecutor in the Adult Therapeutic Court and has held the role for over 6 years. He is also the West Region's Ontario Review Board, a Crown. Also working with him today is the Interim Medical Director, Dr. Ajay Prakash, Forensic Psychiatrist, London Adult Therapeutic Court. Thank you both for being here today.
All right. Good afternoon, everybody. I'm not sure if Dr. Prakash has signed on to the conference yet. I could send him a quick text. He's a pretty busy guy. Let me grab my phone here.
Yeah, take your time, Mr. Yee. It's okay.
Let's see, I'll just give me a moment. Oops. I just sent him a quick text, but I'm happy to start a little bit if you want me to.
Of course we want you to, sir.
Okay. Well, why don't I just start a little bit and hopefully Dr. Prakash will sign on. He's a pretty busy guy usually. I think he's the sort of the lead doctor there now at the Southwest Center for Forensic Mental Health Care in St. Thomas. So why don't I just start? So the Adult Therapeutic Court, we call it the ATC, is We started that in and around, I believe, around 2013, 2014 timeframe. And I took over as the prosecutor in there in about 2014, 2015. And I carried that position until about 2019. And then someone else took it over, and I recently came back and started again into that court 2023. And so with you've probably heard that with most of these therapeutic type courts, the emphasis is on the rehabilitation of the offender. We take into consideration, we factor greatly the needs of and the input of the victims in a lot of these cases. We try and get their input as early as possible, and we try and involve them in the process as well. We explain to them, what stream that the accused person is going through, and we try and get their input. The things that we offer in the adult therapeutic court here in London is mental health diversion. We offer traditional forms of diversion. We call it DAPT in Ontario. And we also, sometimes we will also have the Indigenous diversion. There's a local friendship center called the Namarin Friendship Center, and they deal with the Indigenous diversion. So oftentimes we will agree to the Namarin diversion because sometimes it is a little bit more applicable, but they also have the mental health background. With respect to, we also do the traditional guilty pleas and sentences that as well too. With respect to the criteria, we require a diagnosed mental health illness. I've heard a little bit of the previous speakers. We also will consider we'll accept the concurrent disorders as well. So that's where the mental health illness plus the substance abuse disorder. In the past, I recall dealing with accused persons who've had eating disorders as well. We've had a few of those, and the reason why we accepted him into the adult therapeutic court is we wanted to not exclude persons who have special needs that would not have been addressed properly going through the regular traditional stream of prosecutions. The types of offenses that we would have in this particular court, there is a list of sort of excluded offenses, and mainly they're the driving offenses, offenses involving significant violence. We do not close the door to domestic matters. We have included those particular files into our court. In terms of the running of the court itself, we try and keep a very team approached emphasis. So our team includes the judiciary, the Crown, Defense Counsel, Duty Counsel, CMHA, which is the Canadian Mental Health Association. We have representatives from community support organizations. So these are organizations that will, they're outreach type programs and organizations that deal with a lot of the homeless population in our community. We're very, very lucky in that we have a representative, a doctor, psychiatrist from the Southwest Center for the Forensic Mental Health Care attend every week. And I think we're a little bit unique in that way. We're very, very lucky to have a doctor present every week. We also try and keep a consistent court staff. We try and keep a consistent day of the week we have where we run the court. So it's always Wednesdays. and we always try and have it in the same courtroom. Currently, it is sort of a hybrid court in that we have in-person and we have Zoom appearances as well. I think the Zoom appearances have actually assisted in helping people appear in court when they're, oftentimes we get a lot of clients that are very emotionally unstable. They're not capable of coming into the court physically. They have issues that way, and I think the Zoom appearances is assisted. They often appear with their social worker or their community outreach worker, and we're very grateful for that assistance, because it keeps appearances in check. We try and not request bench warrants unless we absolutely have to. Pre-COVID, we used to have a representative from probation in the court, and we used to have a representative from the local detention center, the Elgin Middlesex Detention Center. We're trying to get those organizations back on board, and so hopefully we can get those team members back in. We try and meet approximately 3 to 4 times per year as a team, and we can discuss issues that have come up, and it just keeps the communication chain going. And I think that's a real key to keeping a successful adult therapeutic court is communication. Sometimes, if defense counsel are having issues, the Crown may not get wind of it. So those types of issues, those meetings help in trying to hash out any kind of issues we have. The CMHA, it consists of 4 members, and they conduct the initial ATC intake for entrance into the court. So they have access to local hospital records, and so when someone is trying to enter into the adult therapeutic court, they go through and meet with a CMHA representative, and they get them to sign a consent. Once the consent is signed, then CMHA is able to access their records, and they tell the Crown that so-and-so is diagnosed with this illness and is acceptable into the court. And so the CMHA, they also, in addition to doing the initial intakes, they are the ones that create the mental health diversion programs for each individual person. Each individual diversion program is specifically tailored to that individual to meet their specific needs. And our diversion programs usually last 6 months. So we would have an update for the first 3 months. And so we bring them back to court and we get a sort of an interim report to see how they're doing. And then we adjourn it for another 3 months to complete the matter. Oftentimes, if there's a victim involved in the offense, we may seek a Section 810 peace bond to follow the diversion. So it kind of accomplishes almost like a probation order, in that there's a program of counseling and there's also victim safeguards. So it kind of mimics that. So we don't ask for the 810 in all cases, but sometimes we will, especially cases involving violence or threats of violence, that sort of thing. We do not, we try and be as lenient and flexible as possible, in that if someone has had diversion in the past, it doesn't exclude them from a future diversion program. We've expanded that because we're focusing on the rehabilitation of the offender, and we know that mental health illness and concurrent disorders are lifelong afflictions, and they're not, oftentimes they're not easily resolvable in one diversion. You know, sometimes they do slip up. We also allow, we're trying to be flexible in that sometimes at the 3-month mark for the update for the diversion, sometimes we get a report saying, you know, this accused has not reported as diligently or has had some slip ups. And so we try and give them some leeway, and, you know, we'll give them another chance and see, look, here's what's happened. Can you know, try and re-engage, and we can continue this program. We try and encourage them to participate in the diversion. And so we're trying to be as flexible as possible. Let me see. The diversion requires some insight into the, for the accused to have some insight into the index offense, into their illness, into the need for medication counseling. So there are some requirements. It's not an easy program, but we also want them to, you know, have some acknowledgement of the issues that they're facing, including the offense. I should speak about one of the unique features, and that is the accessibility to forensic psychiatrists at the Southwest Center. So we have a psychiatrist that comes in every Wednesday when the court runs, and the function of the psychiatrist is to perform sort of on-the-spot fitness assessments. So how that usually works is if we have contact generally with the local detention center, and oftentimes they will email me about certain individuals. They will say so-and-so has you know, not come out of his cell for, you know, weeks. We can't communicate with them. We believe there's some, you know, fitness issues. So when I receive that email, what I usually do is I go on to our scope system and I try and find out a little bit more about the accused. I find out who is acting for that accused. I notify defense counsel and I say, hey, you know, there's some fitness issues with respect to this person. Would you like to, you know, come into the adult therapeutic court on the next Wednesday for fitness assessment? And once they're in that court, there's a little bit of work before that. Once I receive the email, once I receive the okay that they want to come into that court for the fitness assessment, I will communicate with the doctor. I will send the doctor the charge summaries, the criminal records beforehand. And then on the day of the court, the person will generally come in person, and the doctor will go down to cells and meet with them to conduct a fitness assessment. And so once the doctor has completed the fitness assessment, she will come up and communicate with the Crown and the defense counsel and say, look, I believe he's unfit. At which point I can notify, because there's a notification requirement under, I think, 672.6, written notice for a treatment order. So I serve that on the lawyer, and then we'll just do a fitness assessment sort of on the day of. And the beauty about having a doctor there from the Southwest is they are able to tell us fairly quickly bed availability, and I think that seems to be a big issue, having bed space available for treatment orders. And so there's a real efficiency in having a doctor right on the spot, able to to do an assessment and to do a hearing right away. It speeds up the process considerably versus having to, to issue an order through a judge and then having a period of time for the actual assessment order to be completed and then bringing that person back into court to give an opinion and then subsequently like a hearing, maybe a treatment order. So we're able to sort of fast track that. And that's been incredibly successful. It's been an efficient way of doing things. And I think I'm not sure, I haven't heard a lot of the previous presentations, but I think that feature is pretty unique to the London ATC. And I would encourage you, if there's other therapeutic courts that can sort of work that angle out, it works incredibly well. All of our doctors, the team of doctors, there's five doctors. They're all very, very well versed in conducting fitness assessments and fitness hearings. And so we're also incredibly lucky to have a great team of doctors that come in and help the process. They are also able to answer any other types of sort of on the fly questions that come up. So there's an advantage that way. So I've kind of rambled on for quite a long time. So I'll stop here in case there's any questions.
So first of all, I'll thank you for sharing the inner workings of the London Adult Therapeutic Court. It's really, really interesting. It adds to all the other presentations today. As a person out on the streets doing peer support, I worry about those assessments and the forms that the specialists and that you guys do. But I believe what my nurses that I'm working with tell me, and then I cooperate. And we've tried to get some of the best people around here hooked up and almost hooked up for an assessment by a doctor from Southwest, and then it fell through, and then we lost the person. And so I have great losses because maybe those assessments weren't done that you're talking about being done. So keep up the work that is right, even if people out there on the streets like myself we don't know, but we got to trust the professionals. And so that's what we're doing. And thank you, Mr. Yee.
Oh, you're welcome. You're welcome. Is there any questions that you want to answer?
Do you see any questions, Keisha?
I do not have any questions here in the chat, Mr. Yee, at this time.
Okay, great.
I'm going to thank you very much for coming, Mr. Yee. It's a pleasure to meet you.
Thank you. It was a pleasure to present at this conference, and I'm really proud of the London ATC. I think it's a success story in this community.
Oh, Mr. Yee, just before you take off,
yeah,
a question just popped in. If there is a concurrent disorder of substance abuse, does the court require urine screens?
No, we don't usually require those. I think in the past there was a drug treatment court in this community. I don't think it doesn't exist anymore, but I think in that particular court they required urine screening, but we don't.
Thank you so much.
All right.
Okay, well, I'm going to introduce our next
okay, thank you.
Panelists. Thank you very much, Mr. Yee, for coming today. The name of this next event is Success Factors for Drug Treatment Courts, a drug treatment court judge and a drug treatment court alumni's perspective. A drug treatment court graduate and the judge who presided in the drug treatment court in Toronto during her tenure share insights on some success factors. Justice Stephen Clark, His Honor from the Ontario Court of Justice, former presiding judge, Drug Treatment Court, and sharing in the presentation, Nicoletta Person, a research consultant and from the Toronto Drug Treatment Court graduate. The bio for Nicoletta Curson, she graduated from the University of Toronto in 2012 with an honors Bachelor of Arts degree in English Lit. She is also a graduate of Toronto's Drug Treatment Court program. Upon becoming an alumni of the program in December 2020, she started volunteering with Right On, a prisoner rights organization that seeks to empower incarcerated individuals through information and knowledge sharing. Nicoletta is a peer consultant on the cannabis and drug treatment courts in Ontario research project with CMHA Ontario and JHSO, and a peer researcher with the MAP Justice and Equity Lab at St. Michael's Hospital. As a speaker and person with lived experience, she brings a unique perspective on the sources of trauma inherent in the criminal justice system, as experienced by the criminalized population and advocates for therapeutic alternatives to incarceration. Yes. Sorry, Nicoletta, that's all wonderful. Thank you, everybody, and welcome.
Yes, thank you. Can everyone hear me? It's Justice Clark.
Yes, sir.
Thank you very much for having me or having us. Just allow me to introduce, as you just have, Mr. Bolton, Nicoletta. I want her to be the star of the show because she is. I'm merely the wind blowing quite forcefully from time to time beneath her wings. I am retired as a full-time justice now. I do sit on a per diem basis. I was in the drug treatment court in Toronto for the last 5 years of my tenure after almost a 20-year degree on the bench, and the last 3 as team lead. So I have the same lived experience with Nicoletta as she has had herself going through our journey together. She is the person you really need to hear from today in our brief 20 minutes. As you'll soon discover and as introduced, she is extremely articulate, insightful, knowledgeable, given those lived experiences, and is happy, I think, Nicoletta, to share some of those experiences today. Let me just very briefly set the context and the background in these next few minutes, and then I'm going to turn to Nicoletta, who can hopefully impart some information, if not knowledge and wisdom, about how she became addicted, how did she get out of it, so to speak, and what was a significant, almost singular negative and indeed a positive aspect of her drug treatment experience in Toronto. Time permitting, in the last 5 minutes, I'll try to summarize with some takeaways as to how we measure or gauge success, and that is in quotes, in the drug treatment court. Let me set the tone and the stage by saying that Nicoletta and I first crossed paths, in fact, locked horns, one might say, with one another in 2018. It is almost an understatement to say that there were peaks and valleys in our relationship. In the first year, 2018, even Nicoletta would have to agree with me, I'm sure, that she was the artful dodger. We played cat and mouse with one another, and we often went in circles as we, the treatment team and the court team, tried to find an engagement entry point with her. Initially, Nicoletta, like many others, had or took the attitude that she would play the game with us and then quite frankly, fake it until she made it by going through the motions with the almost singular view of avoiding the threat of jail or incarceration. Without losing my neutrality, I thought and hoped, empathy, understanding, with a lot of what I will call deep listening to her and the other treatment and court team members, I convened a conference, which was in fact the first and only time that I did so with any of our participants, where I actually got off the bench, off the perch, so to speak, to ameliorate the perceived or real power imbalance that I could sense Nicoletta had with us, and proposed with the input of others that she prepare a written assignment as a sanction for one of her many shortcomings in not coming to court, not complying with terms of her treatment modality. And we knew that she was prepared to do this given the benefit of her higher education, but to help us to help her by better understanding her needs, wants, changes that she'd like to make, what steps she planned to take, what were her next steps, and what things might get in the way or interfere with her plan. In March of 2019, after weeks, if not months, of pulling teeth, after hearing just about every sophomoric, although creative trick in the book, from the dog ate my draft to the laser printer ran out of ink to a myriad of other adolescent excuses, we received a very powerful composition describing and plumbing the depths of her despair, as only a university English major as she was could create. I won't go on about its contents, except to say that the main theme had to do with her always believing that she would be a princess living in a castle with a moat around it for protection and security, only to find, rather ironically, that with the onset of addiction, the castle had no gate or door to get out, and that the moat was filled with demons. We, the team, were able to use this assignment to assist in formulating and employing various treatment modalities and techniques. And so, ladies and gentlemen, I now give you that Princess Nicoletta Curson to tell you something about her journey and her road to success. May I also underscore that Nicoletta has not been selected as a cherry picking to demonstrate the success and the gold standard of the program. Just so happens that Nicoletta was a successful participant, graduate, and has the ability, with her permission and her agency, to impart some of this information to those in need. So with all of that, I turn to Nicoletta. If you have any introductory comments, Nicoletta, we're happy to hear from you. Otherwise, I really go to question one, which is how and why did you become addicted?
Yeah, I just wanted to start by saying that that was a very good description of our initial relationship there with the court team and the treatment team as well. And it took some time to change, but that writing assignment really did not only provide the team with insight, but it provided me with insight about myself, even though it, took me weeks or months to actually get it in. But once I did, it gave, also I shared it with my father, and it gave him an idea of my internal experience. So I'll quickly move on to the questions. So the first one, why? Why did I become addicted? This is never easy. It's everything in life, I think, is simple and complex at the same time. So I could very simply just say, generally, the root cause of addiction is trauma. So I think that's true for the most, if not all, people dealing with addiction. But it is always more individual and more complicated than just that. So I had a magnificent childhood. And then when I was a teenager, I started feeling differently. My emotions were overwhelming. I didn't know why I felt this way. I did go see mental health professionals, and I was either misdiagnosed or undiagnosed, and the diagnoses never fit. The medications I were given were, they weren't beneficial, to say the least. And then I think due to this, what I later found out was borderline personality disorder, 20 years later. I ended up in a lot of scenarios that were tumultuous, including when I was a teenager, an abusive relationship. So I was in this relationship for 4 years, and the first few months seemed normal, and then very, very quickly escalated to physical abuse and sexual abuse and emotional abuse and controlling behaviors and all the standard things of intimate partner violence. And I did not have a support network because I hid it from everyone. I assumed, I was hiding it from my family to protect my family. I was hiding it from my friends to protect my friends from him. Or at least this is what I believed. And I was at no point during this relationship, there was a lot of police contact. I was never provided with any resources other than, do I want to report this person, which I did not due to fear of retribution. And so this was 4 years long. It ended, he ended up, he died. And so I thought, okay, now I can, be normal, do all the things that normal people do. So I went to university and I really tried just to do what other people do, or like at least seem like I am living life in whatever normal meant to me at the time. And I realized, only much later did I realize that this actually was a traumatic experience. I know that seems obvious, but I didn't see it as such at the time. I thought, okay, this is no big deal. These things happen. Get over it, move on with my life. And sometime during my BA, I discovered heroin. And heroin made me feel like I can finally be normal. I can deal with my overwhelming emotions because now they've been brought down a notch. And I assumed that this is how other people feel. And this is why, but maybe without that. And this is why they can make it through life, because they're somewhat detached. They're not so sensitive, so invested in not only what happens to them, but to the people around them and in the world. And, the despair didn't seem so overwhelming for everybody else. And I thought, okay, so this is how normal people feel. I just have to take this every day and I'll be like everyone else. And so I guess that is how and why I became addicted.
And I certainly appreciate this is a very simplified version of the various layers of the onion, so to speak. But given our time constraints, we're more whetting the appetites of our listeners. Could I just ask you then to address the second question? How did you address it and get out of the spin cycle, so to speak, through drug treatment court, and how did they assist?
Yeah, so it was really all thanks to drug treatment court, because ever since, I was 16 when all the, I guess, like mental health issues, if you will, began, and then the toxic relationship, and then all the other things. It was a 20-year journey. And if it hadn't been for drug treatment court, I don't know where I would be. I mean, I have a good idea. I'd be dead, because there were many times that I contemplated and attempted to do that. So basically, like, I had been and had contact with the court system before, and it was just incredibly dehumanizing. And I know the word Kafkaesque gets thrown around a lot, but what I mean by that, and I think what is meant when people say Kafkaesque, is that it's threatening, confusing, that you feel lost in this process of bureaucracy that you just can't understand and that you have no support with. So that was really my experience with the system. Like, you're just this non-human person who is brought out, paraded out into this box after you've been there, either all night or however long, and you're gross and dirty and maybe sick if you're using, and nobody's actually looking at you except the audience in the court, but the judge and the crown and even, the lawyer, they don't really look at you. They don't want to know you. So it's all very cold and detached and impersonal. And yeah, it was extremely unsupportive and re-traumatizing, because it was the same sort of control that I felt in the relationship, in the abusive relationship. So DTC was so different. Not only, of course, specialized courts talk a lot about trauma-informed approaches. And I think that's extremely vital. I do still think that we need to take a deeper look of how to go about that, how to go further with that, what that actually means, like both in our specific courts, but systemically and structurally.
And I'm sorry to interrupt because time is now our
Oh,
enemy. But
yes, okay.
Would you mind just touching briefly? I appreciate that DTC
Yes.
took a trauma-informed approach. I think your circle of trust developed with the treatment team. I know
Exactly.
that when you and I were discussing how to put this together, that the primary therapist or therapists that you had
Yes.
were absolutely vital and key to this. Could you just touch, just so our listeners are aware of that situation where you had those feelings of your life being over, having no hope,
Right.
and the random way in which you were rescued?
Yes. So basically, I did during my addiction, especially there towards the end, I felt completely hopeless, like my life was over. And I did want to end it. And I tried a couple of times. And there was one instance where I actually overdosed, and the overdose was an accident. I ended up in the hospital unconscious for like a day and a half, but there was another user there, I guess, and he gave me 2 injections of naloxone and called the ambulance, which is why I ended up in the hospital. And I was so angry with him. I was furious. I told the guy, "Oh, I hate you for doing this to me. You know, how could you? This was my opportunity to get out." And you know, after my experience with DTC, I am honestly so grateful to him, because that would have been the end. And I don't know if I'll ever see him again. I hope I do, but I'm so thankful to him and to the team, the court team, the treatment team were so vital in believing in me when I didn't believe in myself. And that really made a difference.
Thank you. There may be a Netflix documentary in the making here, Nicoletta. Just finally and very briefly, before our screen goes dark, perhaps, just turning to the last question, which is, what about the DTC experience? There were some negatives. The positive, I think we can all appreciate from what you've just said. So maybe I'll just speak for you and you can say yay or nay. The positive that we had discussed is really that it humanized you, I think is what you're saying, and that it's allowed you now to not only give back in all the ways that you're doing that, but you felt that safety and trust over time due to that dedicated and consistent and committed approach by the treatment team and the court officers. If I've just spoken for you, if you don't mind, but I think it's important that we
Well,
finish
you
off.
knew what I was going to say.
Yeah, and just so you could finish off, so it's a balanced presentation about a negative here, because rather than saying negative, just what could DTC be doing better in terms of, you know, against the background of this trauma-informed approach that you've mentioned?
Right. So the one experience that like really set me back was when I was making some at least internal progress. I was arrested and I did go up for bail in front of the DTC in a couple of days, but I was not immediately bailed out. So I stayed in there a little longer and then was eventually bailed out. But that experience, I don't know, I mean, I have some idea why, but it was really incredibly traumatic. I was extremely sick in there, and just, I had been to jail before. I had been to prison for a year, and that wasn't nearly as traumatic as that brief time. And it really set me back so much. So I think, of course, clients in DTC are going to get arrested. It's just a process until you become you get out of that lifestyle. But I think doing everything possible to mitigate the trauma and the length of time, and truly being compassionate and supportive and trying to mitigate any trauma that may arise from the other side of the criminal justice system.
Thank you very much. Mr. Bolton, I don't want to abuse the time frame that we have. Is there, are you moving on to another unit now, or would I just have a few minutes to merely suggest to our listeners what success is or isn't, or what it might mean in the drug treatment court?
Absolutely, Your Honor, absolutely. We're going to go to lunch break when you're done.
Okay, thank you very much. I'll merely say the following, if you'll permit me. Really, the two main pillars are to focus on promoting connection with the program, which is perhaps stating the obvious by the participant, and thus really improving the stability and quality of life of our participants. There are 4 indicators that we look for: changes in drug use, obviously, changes in criminal involvement, improvements in quality of life, and of course, the underpinning of drug treatment court engagement. None of these are absolute based, they're progress based. The changes in drug use, decrease in frequency, quantity, potency, severity. Changes in criminal involvement means decrease in frequency and severity of charges, decrease in number of arrests and time in custody. Improvements in quality of life is the essence of what we strive for. The client is housed, has primary care provider or family doctor, has mental health assessment and support, access to psychiatrists and or medication where warranted, reestablishing relationships with family and friends, new and reestablished healthy leisure activities, identification documents being obtained, and education and training being planned, volunteer work, and hopefully to those who are so inclined, jobs. And hope, of course, envelops all of this. The engagement, we know as the clinical team and the court team with our respective years of experience, is that none of this happens without positive relationships and safety, the feeling of safety within the program. The client experiences that connection, therefore, with the treatment and support team, and it demonstrates a shift from the external motivators, which is the finger wagging that many of our participants have been on the receiving end, is if you don't stand up and do the right thing, you're going to jail, the big external motivator. We try to shape that and of course turn it into the internal motivators, which are the most important one, which is wanting to get help, wanting to get clean, and wanting to move on and strive to reach that quality of life. So none of these, the aim is to be mindful of each participant's ability at the time in the moment for them to be able to change. Put another way, what we should be doing is trying to accept one's behavior at his or her best effort at that time. And by taking this holistic approach, it's important to be aware that our participants are not bad people trying to be good. They are unwell people trying to become well. And a trauma-informed approach requires us to ask at the appropriate time, not what's wrong with you, but what happened to you. And the best practices, as I've already alluded to, I'll merely restate them, should include consistency, continuity, ability to motivate, and building trust. And of course, we all know, whether we're raising children, family members, or in courts, garnering trust cannot be forced or fabricated. And so the tools that drive the jurist's influence and that of the whole treatment team and court team is an effort to maintain a sense of legitimacy with the participant, including being the voice of the team, demonstrating neutrality, showing respect, protecting rights of the individual, all of which equates to a generalized concept of fairness. Treating individuals with dignity and civility promotes a felt connection, which in turn affects compliance and acceptance of the team's decisions. Hopefully, the clients or participants over time will get to see the judge in action, so to speak, as a kind, welcoming individual who is being fair to all. And part of the program is that each individual must stand before the court and give his or her update or testimonial so that they can have the opportunity to see how the judge is dealing with everyone, not just the teacher's pets, so to speak, which I have to confess is what Nicoletta became to me, but in that fairness to all. And most importantly, every interaction with a participant for us is an opportunity for engagement. And rather than moralizing about one's character flaws, the judges were to, and hopefully we do, assume the role of confessor, cheerleader, and coach. And more simply put, people value fair procedures because they're perceived to produce fair outcomes, thereby making individuals feel validated and worthy, and that you know them because you follow along with their story and their journey hand in hand. And an individual will live up or down to how he or she is being addressed and treated by the court. So as Nicoletta knows, for all of her experiences, it's a long road, and we, the treatment team and others in your life, can walk it with you, but only you can walk it alone. ultimately. So with all of that, ladies and gentlemen, much more that could have been said, as I'm sure with all of our presentations today, but thank you for your time, and I will invite questions if there is any further time permitting, Mr. Bolton. But thank you again for giving us this forum. I think this is the soft skill part of the thing, and Nicoletta is just a remarkable young lady, and if I could tell you more about the before and after, or if Nicoletta could, it is quite the story. So please understand that this is not representative of many of our individuals, and we don't set out to produce the Nicolettas of the world. And that's what I meant about meeting people where they are at the time, given their abilities. So I'll stop there, because otherwise I am prone to going on and on. So thank you.
Thank you.
And Justice Clark and Nicoletta, we just do have some comments in the chat thanking you guys for the presentation. And Nicoletta, thank you so much for sharing your experiences with us. As the survivor of intimate partner violence, it's good to see that we not only survive, but we can thrive and be inspirational and motivational. So thank you so much.
Thank you so much.
That's for you, Nicoletta.
And for you, your wonderful speeches, as always.
Yeah, you were both very impressive. I would love to hear more and more from both of you. Maybe another time, maybe tomorrow, I'm not sure.
Yes.
Nicoletta, I've seen you on a couple of the events, and it's a great pleasure to be getting to know you through listening to you more and more. Can I say that it's wonderful to see a person doing peer support, one of us that makes it and gets out there and is getting to change things, because you are the kind of person that the world will listen to. And I know that because I'm going through something similar. It's wonderful working with the top tier professionals that I've had so much faith in for a lot of years. I've got 40 years of super counselors under my belt since I got off the streets. They're pretty well everything to me. I didn't have a family. I didn't have all these things, but I did find community through professional help. Yeah, I'm 6 years clean almost right now, but I still have 2 CMHA workers because addiction services joined CMHA, and I still have my addiction service work. You know, because they just know that I'm involved so deeply on the streets, and it's such a miracle that I've made it, that they don't make me let go yet, you know, and I didn't have to let go. The severity of our situation, I'm still healing after 5 years. So if we're that badly damaged that we're still healing after 5 years, imagine the help that we needed at the beginning, and for us to try and figure things out is so hard for us. I know through the work of the people I work with out there that they do all want help. That it's a myth that they don't, but at the same time, it doesn't look like we want help from the way we act when the help's offered, and everything's upside down, but upside down goes both ways. And but together we can bring things right side back up through the loving relationships of the professionals, and us being able to reach out to you guys and trust you, and you guys be there. It's amazing. I just think that peer support is key. Let us be part of your guys' wonderful team, and together we can do it. You guys are wonderful examples. Thank you so much for coming today.
Thank you, Mr. Bolton. And again, Nicoletta would be the first and perhaps the last to say that, as we had mentioned, the primary therapist or therapists here are just the magic wand, and Nicolette had the benefit of 2 wonderful therapists, as all of our participants in the Toronto program do. I'll finally say that for anyone who's interested in seeing how this court works in particular, not saying by any means it's the gold standard, but it's been around the longest. And we had the benefit of not only Justice Bentley, who started the program, but Justice Mary Hogan, who became that gold standard. And then along came me. I feel like a place setting in between Justice Hogan and now Justice Heather Pringle, who is on her way to her own gold standard. And if you could see these jurists in action, and there are others on the team, you know, they're the quarterbacks and they're the ones who become the voice of that treatment team and the court team. So every cog in the wheel is at work on every occasion. So thank you again.
Thank you, Nicoletta. Thank you, Your Honor. We're going to go to lunch break, everybody, and we'll see you at 2 o'clock.
Thank you. Our pleasure.
Thank you.
Thank you, Nicoletta. We'll talk soon.
Welcome back, everybody. We have a people with lived experience round table with Judy Burns, manager of the Drug Treatment Court of Regina, Megan Jasper, the Drug Treatment Court, she's Drug Treatment Court alumni. Megan grew up in Yorkton, Saskatchewan. She comes from a good family, no addictions history. At 14, she started using drugs, participating in risky behavior, and at age 16 was arrested for the first time. This would be the beginning of years-long battle with addictions, incarceration, and risky behavior. In 2017, she entered for the first time Regina Drug Treatment Court. She had never even thought about going to detox or treatment. She'd never seen addictions counselor. Jails are always a detox. Once I pick up, I don't stop until I'm incarcerated. Although I didn't have any childhood trauma, once I started using, my trauma came with that lifestyle. Regina Drug Treatment Court gave me an opportunity that I'd never had or even thought I needed. Once entering the program, I was immediately connected with an addictions counselor. Through her and the MRT program, I was able to change my thinking. I learned accountability and how to see the role I played in things I used to think I was a victim of. I owe my life to Drug Treatment Court and MRT. Today, I have over 5 years clean from alcohol and drugs, have not relapsed once since entering the program in 2017. I graduated December 2018. I attended university where I received my business certificate. I now reside in Moose Jaw, Saskatchewan. I work at the John Howard Society, where I'm able to work on the front lines of the current addictions crisis, as well as being an advocate for harm reduction. I have also become a family partner of Saskatchewan Health Authority to work towards changing policies to better represent people with addictions in the treatment field. I have also shared my story in 2 documentaries, Stop Messing Around and The Beast Inside My Head. RDTC has given me a life I didn't think I could ever have or even want. Today, I am trusted and reliable. I have relationships with my family. I've become a valuable member of society. I am living proof that an addict can find recovery. Wow, awesome. Also, in this group, around the round table of lived experience is Nicoletta Curson. She's also Drug Treatment Court alumni. She graduated from the University of Toronto in 2012 with an honors BA degree in English literature. She is also a graduate of Toronto's Drug Treatment Court program. Upon becoming an alumni of the program in December 2020, she started volunteering with Right On, a prisoner rights organization that seeks to empower incarcerated individuals through information and knowledge sharing. Wow. Nicoletta is a peer consultant on the Cannabis and Drug Treatment Courts in Ontario Research Project with CMHA Ontario and John Howard Society Ontario, and a peer researcher with the MAP Justice and Equity Lab at St. Michael's Hospital. As a speaker and a person with lived experience, she brings a unique perspective on the sources of trauma inherent in the criminal justice system, as experienced by the criminalized population and advocates for therapeutic alternatives to incarceration. Also on this team, the round table is Melissa Duck. She's also drug treatment court alumni. Melissa is alumni drug treatment court at the Center for Addiction and Mental Health. After a long battle with drugs, she graduated the program in July 2019, has been sober for nearly 5 years. Melissa faced many obstacles throughout her addiction, such as incarceration, homelessness, spousal abuse, and having to place her firstborn son up for adoption. She overcame each obstacle one step at a time, and drug treatment court gave her the opportunity to do so. In January 2021, she started a program at George Brown College called Transitions to Post-Secondary Education and graduated with honors in August of 2021. In 2022, Melissa gave birth to her second son and has spent the last year raising him with her partner, who is also an alumni of the Toronto Drug Treatment Court program. They are expecting their third child in May of 2023. Congratulations. Melissa has obtained so many of the goals she has set for herself and continues to work with Drug Treatment Court to maintain being the best version of herself. Absolutely. Wow. Welcome to the round table of lived experience people.
Thank you. Nice to see everyone here today. Melissa, I'm happy you're here. The baby didn't decide to come early. We had some worries about whether or not Melissa would even make it to the panel because the baby is due any moment. So we're going to do a round table with our panel, talk about barriers, challenges, successes, and best practices. So how can DTCs improve? What are we doing that we could look at changing and get it from the people that get the services from us? So it's a great opportunity to look at quality improvement from service received by participants. So first question we'll go to is, what are the barriers that you see? And we didn't really decide who's going to talk about what first. So whoever jumps in first can go, and then the others can add in. So barriers to drug court when you were getting into drug court.
I can go first. I think if we look at like when we're still sitting in jail waiting to get into drug court, I think there's a couple of things there, but the one that sticks out the most to me is housing. Here in Saskatchewan, you know, we're always in the paper about our income assistance not giving enough, and obviously we can't work when we come in. It's hard to even sign up for income assistance while you're incarcerated. So you have no income, you're getting out, and you need to find housing. If you don't have a place to go, like a family member, a friend, or sometimes those places are toxic, right? Those are the environments that got us sick or made us sick or kept us sick, you know? So trying to get into like a housing corporation, like a low income housing, is impossible while you're incarcerated. I always say this, the words safe and affordable are never in the same sentence when it comes to, you know, being on income assistance, because the housing that is safe, we can't afford. And the housing we can afford isn't safe. So, you know, when you're worrying about going home to people that are like still using, and then, you know, trying to stay clean throughout the night, like it shouldn't be a dangerous place that you're going to when you're not in drug court. And, you know, for me, I'm really grateful because Regina Drug Court, you know, for the females, we had Kate's Place. You know, it was in the hood of Regina, and, you know, it wasn't maybe safe outside the building, but at least in that building, we had, you know, something that we could afford, and, you know, it was doable, right? The men weren't so lucky. So I don't know if this is an issue with other drug courts, but I know, like, if we didn't have to stress out and worry about going home after drug court, it would make our treatment a lot easier, so that we could focus on what we're receiving.
Toronto, any comments on that?
Yeah, I also find housing to be a barrier when entering the program, because when you may not have housing to go to. Also, I find that often for women, or in my experience, it's tied up with like intimate relationships. So maybe you're with staying with a partner, or homeless with a partner, and it's difficult to just separate yourself from that part of your life as you're entering the program. The relationship might be toxic. You may not be able to extricate yourself from it. And I find that, needing to have stable housing, which for many people is inaccessible, is an unrealistic expectation and a barrier to entering.
Okay. Anyone else have another barrier they want to bring up?
I can bring up a barrier.
Okay.
So one of the things that I feel is a barrier is that DTC doesn't have enough partnerships within the community and within the jails. So for example, when women are released to go to court, we are not given like Suboxone or methadone. So we are sitting all day without getting medication that we need. And if we're released from jail, then we're basically going into the streets without any opioid replacement, which in turn usually leads to relapse or to overdoses, depending how long a person's been in jail for. But the men in Toronto, they get their methadone and Suboxone before they leave for court. So I think that's a huge barrier. And I feel like if DTC had maybe like a doctor or a pharmacy in the community that clients could go to as soon as they're released from custody to get all that stuff sorted out, would be very beneficial. As well as, it's not just like the methadone and Suboxone. People are on antidepressants or antipsychotics, and if you're taking it in jail regularly and then coming out and not having access to it, that's a huge issue for mental health and physical health. And I also know from like the team's standpoint of view that it's not always so easy to get in touch with like the jail's medical staff or social workers, which makes it extremely difficult for clients to get their medication. So I feel like if we could build like some sort of bridge to have more access to the staff at the jail or doctors in the community, that would be super helpful for clients.
Okay. Anyone else?
I just want to add to what she said. Like that's, I 100% agree. That's one of my challenges is, like with this fentanyl crisis and opiate crisis that's going on right now, you're seeing more and more, and they're coming in younger. And, even in Regina, we've lost a few participants. So I guess what is all of the drug courts going to do for harm reduction? Like, does this involve Narcan and naloxone training? Like as soon as, people are staff members trained, are people being given kits as soon as they get out? Because, we got to keep people alive long enough so that they can access this treatment. And like how she just said that men are being able to get onto their methadone, Suboxone, whatever, and the females aren't. Like, so there, maybe better communication amongst, I know in Regina, we used to have a doctor, but I don't think we do anymore, that used to come and visit us. I'm not sure. I know when I was there, I was lucky enough to be able to go and see him, but yeah, we got to keep people alive. So there's not, they don't have the option of going to treatment.
Just to also add on the same topic, not just like when you're leaving the jail to go to court and getting your dose, but when you go into jail, if you're not already on methadone or Suboxone, they're not going to give it to you unless they know like you're already sentenced and you're going to be there for a while. So if you're spending, a few days, a week, a month, whatever, until you get bailed out again, you're not receiving treatment. So if the DTCs could somehow partner with the doctors or social workers or whoever, as Melissa mentioned, to get people who are in the program, so clearly they have the addiction issues that the treatment team knows of, can communicate this to the doctor at the jail so that they can be given medication. Because I know in my own experience, like I was in withdrawal, and as soon as I got out, the first thing I did was purchase fentanyl. And so, yeah, it was definitely a challenge, to say the least.
Okay, the next section would be challenges. So not just a barrier, but something that's there, but is still challenging for you while in drug court. Can you give me some examples of that? Nicoletta's nodding her head, so go ahead.
Yeah, sure. So this actually like sort of goes to both barrier and challenge, because having to enter a guilty plea, I think that's problematic, especially because by that time you may have a multitude of charges, and some of them are probably legitimate, and then some may not be. So I think and of course, it's going to result in a criminal record. I also think like there was, not just with me, but like people in the program told me the same thing. It wasn't clear that you would have a criminal record after the programs. There was some sort of assumption that like if you completed the program successfully, you would not have a record. So I think that is, you know, challenging not only while you're in the program, but after for a long time. And also, we did touch on housing. Also, there were, when I first started, there was a group that all the women had to attend. It was outside of the DTC. It was in the community and occurred 5 times a week from like, I don't know, I think 9 a.m. to 4 or 8 to 4, something like that. And one of their requirements was that you had to be sober for 24 hours prior to joining the group. But I had just entered the program. I was in active addiction. I could not be sober for 24 hours because I would be very ill. And it was just an unrealistic expectation. I did not complete the group. They ended up, you know, kicking me out because I kept sort of like falling asleep or whatever, nodding out. So I did not complete the group. And because there are significantly less women in the Toronto DTC, there weren't as many other options for groups for women. The men had regular groups. I think it's like 3 times a week. And we maybe sometimes had it once a week, but usually not, just because there weren't enough participants. So that was a major challenge.
Okay. Melissa, did you find that as well?
Yeah, for sure. We have I think when Nicoletta and I were in the program, there was maybe like 5 or not even 5 women in the program. And I believe I know what program she was talking about the 9 to 4, which kind of brings me to one of the challenges that I think is, yes, we need equality in the programs, but we also need equity. Everybody has their own individual needs. So I feel like if DTC and like some of the other programs that we have to participate in to continue with DTC looked at both equality and equity and kind of combined it more together, I think we would have maybe a higher success rate. And then also to piggyback off of what Nicoletta was saying about like pleading and not knowing all the details before going into drug treatment court. I feel like it would be really beneficial if there was like more education or more promotion within the jails about DTC, because there's so many, especially with the women, there's so much stigma and fear about going into a program like that. A lot of women have children, and then they're in turn afraid that like CAS is going to get involved and they're going to lose their kids. So I feel like if maybe one of the staff members from DTC could like facilitate a group in the jail to like talk about exactly what DTC is and how they can help and kind of eliminate that stigma and fear amongst the women, I think it would be super beneficial.
That's a good idea. Awesome. Okay, any other challenges?
I have another thing just to add, because I have this under my barriers, but you know, like I don't know how the other drug courts work, but I know in Regina here, we don't take people like there's certain criteria you have to meet just in order to be able to attend it. And one of those things is about the weapons charges. And for me, like, I don't know, for me, I carried all the time. I carried weapons all the time. I'm just grateful that I was only caught with a knife and they were able to drop that for me to go into drug court. Otherwise I wouldn't be here today. I think that I don't know what would have to change, like if there'd have to be like a security guard or what there would have to be. But I feel like that at least here in Saskatchewan, the most of the people that are being charged with drug charges right now are carrying weapons. And, you know, just because of where I work, I see it, I'm in the court slots, I see it all the time. And these people aren't qualifying for drug court because they had a gun on them or they had, you know, a knife on them. But I can tell you from my past experience that I'm just very grateful that I was not caught with what I usually carried. Otherwise I would not be sitting here today. So.
Okay.
Sorry, can I kind of piggyback off of Megan as well?
Yes.
So another criteria, like to get into the program, for myself, that was like a barrier and a challenge was my co-accused, who was also my partner, was in the program before I got into the program. And it took about 4 months for me to get accepted into the program. And usually they don't allow co-accused or partners or family into the program together. And luckily they took a chance on us and we definitely gave them a run for their money. But I think that it would be beneficial. Like, it's not fair that you know, they choose to help one person, but because 2 people have been charged together, the other people can't get the same help that they need. So like, I know there's a lot of confidentiality issues and you know, things like that, but I feel like from 2 people that have graduated the program and done it successfully together, I think that it's an opportunity that the court team should definitely open up to more people.
Can I ask, Melissa, was there any couples counseling done with you as a couple while you were there, or was it both individual?
I think it was more individual than couples. Like I said, the confidentiality stuff really is tricky for like the therapist as well as like the court team. I don't know how they did it, but they were able to do it for us. And you know, I would love to see more couples, because, you know, if you can, so to speak, kill 2 birds with 1 stone and, you know, get people clean and sober and have that support together, it's a phenomenal experience.
Great. Okay. Okay, is there any other barriers or challenges, or are we going to move on to successes and best practices? Go ahead, Nicoletta, you look like you wanted to say something.
So once again, I'm just going to mention housing. I think is really, we touched on this. I think it's really problematic for people to, from a place of not having housing, actually meet the requirements of the program, like showing up to court twice a week, going to see your therapist. It's really difficult to do that without a base level of stability. But also in relation to that, the executive functioning impairments that may be that people with active addiction may be suffering from at the time. I think just some more understanding around that. So like showing up to places, coming to places on time, all those sort of things I think are very problematic, if not only if you're in active addiction and don't have some form of stability in your existence, but also people come in with traumatic brain injuries, with histories of violence that have impaired their cognitive functioning, you know, and a myriad of other issues. So sometimes I think that expectations need to be really individualized. and come from a place of compassion and trying to serve and help the individual, as opposed to having a more sort of broad set of rules.
The cookie cutter approach doesn't work, right?
Exactly.
Yeah. I hear what you're saying. It's not easy when you start. Your hair's not clear. You're not used to structure, right?
Mm-hmm.
Anybody else have that issue? Okay. Move on to something else then. Somebody tell me another success. What worked really well in drug court for you?
I can talk about, I don't know if Toronto does it. Like, I don't know if you guys have the moral recognition therapy books, like the MRT books. If it wasn't for MRT, I wouldn't be here today. Like, it changed my thinking. You know, I used to always think I was the victim. You know, I had really bad things happen to me while I was using. And, you know, when you say the word, you know, when you're sexually abused, you always think that you're the victim, right? And it gave me the right to hurt everybody around me because I was the victim. And, you know, I worked with a counselor, and I worked with a whole team of counselors at drug court, but it wasn't until I did MRT that I finally stopped using victim statements and stopped blaming everybody around me and started to see the role I played in my circumstances. And, you know, it also, not only that, so that helped me, you know, change my thinking, but then the biggest part was the goal setting, right? Because after drug court, it's all about goal setting and what you're going to do afterwards, and, you know, working towards a better, healthy life, and not falling back into that old trap. And if it wasn't for MRT, there's no way I would have been able to, you know, today I work on the front lines, and I see my drug of choice. I see people, you know, I see all these triggers, and people are always saying, like, how can you do that job? Like, how are you able to not, you know, want to relapse? And I don't, because MRT has given me, you know, a different way of thinking today. My first thought isn't wrong all the time anymore, like it used to be. Which wasn't that long ago, but.
Okay, good.
What does MRT stand for?
Am I saying it right, Judy? It's moral recognition therapy, right?
Moral recognition therapy, yeah.
I can give you the definition. MRT is I wrote it down because I love MRT. MRT is an effective, systematic, cognitive behavioral approach that treats a wide range of issues, including substance abuse, domestic violence, trauma, parenting, job skills, and other issues. And so they have like little work, like we did the Escaping Your Prison, I believe, booklet. And now they've implemented, like that was when I was in drug court, they've implemented other books. But I can even say, because, you know, before I was in drug court, I dated somebody in drug court, and the MRT books weren't there. And, you know, that whole group of friends that he had, you know, most of them went back out. And I feel like they went back out, like they stayed clean, they graduated, but they went back out later on. And I feel like MRT is the reason why we have so many grads being successful today, you know, because we've learned to live, we've learned to change our thinking. Because addiction is, you know, it's a disease of the thinking. So yeah, it taught me how to pick healthy role models, you know, like I remember in the first, I think it was step 3 or 4, where you have to pick a role model and why they're your role model. And, you know, and when I looked at that book and I looked at my role model, it was all based on like ego, money, and, you know, fancy cars, and a big shot house. And, you know, and then when I picked when I got to step, you know, after I did the goal setting and all that, and then I picked my next role model, and it had completely changed. So it just shows my thinking, how it changed in a few weeks. My next role model, it was because she was a woman that was empowering, and she showed strength, and it, you know, and it was completely different from, you know, the last time I had done that exercise, which just really shows that I changed my thinking.
Went from material things to other things.
Yeah. Yeah. And then I wanted to, you know, stand up for women's rights and beliefs and things like that. And, you know, what really, because I'm always looking at MRT stuff, and, you know, what it kind of goes in, yeah, we're on successes, but I would like to see, you know, some of these other books implemented, like, especially like parenting one, like Toronto, if you guys are struggling with groups for women, like starting an MRT group that's based around like trauma and parenting. Like I would love to take the parenting one. I'd like to take the domestic violence one, because even though my domestic violence relationship was years ago and I feel like I worked on it with my counselor, there's always, I would just love to take it. There's always things that, triggers that come up, PTSD comes up, and I think that would really help me.
Yeah, I'm not sure if we do MRT in Toronto, maybe for like the last, I don't know if it's like 6 weeks in the program that you do it just before you graduate or complete the program. But like most of the groups that we do, I think are based more in CBT, which, is helpful as well. For me personally, I did participate in the groups that had more of a CBT basis, but I also did an outside group that was DBT, and that's what I found like very helpful for me personally. So yeah, I think all of these modalities, it's finding which modality works for each individual. And I think it's important to have a myriad of options available, both with the treatment team and in the community.
You're looking at individualized treatment plans and not a cookie cutter approach is sort of the message you're giving.
Yeah.
Okay, what else did you find that worked for you in drug court?
So I think Nicoletta kind of touched on it. It may have been hard at the beginning with having like regimented schedules, like meeting with your counselor on certain days and doing groups on certain days and having court. But for me, that really worked. I was by myself. My partner was incarcerated. So having like those schedules and things like that really helped take my mind off of like when I'm going to get my next fix. And it also like it gave me a purpose to wake up in the morning, be like, okay, I have to be somewhere and I want to be on time and things like that. And I think without having that scheduled routine in my life at the beginning, I don't think I would have done as well as I did. So I think that was very successful to have, or like it's a good thing to have in the program. And also, sorry, go ahead, Judy.
No, go ahead.
Also, like they the DTC, they also help with like getting on Ontario Works and Ontario Disability. They also know like all the ins and outs, or where you can get like a legitimate job. A lot of people have criminal records, so we can't get hired, but they know places where you can go and you can volunteer, or you can get work, or you can do school, things like that. So those are, I think, another huge success of DTC.
Yeah, the more resources in the community, the better, right?
Yeah.
Okay. Anyone else? Megan?
Yeah, just to kind of add there too, I do have about the structure written down. The structure, drug court, the structure was really hard to adapt to. I'll tell you that. But once I did, it prepared me to be successful after drug court. It taught me how to be on time. I know I like to be late. I hated giving up my fish balls for my lates, but today I'm not late when I go to work. I'm early. So it taught me those things. And one thing too is like the wraparound services, just because I'm always advocating about this too now, is that I think drug court, why it works so well for me is that if I would have been at drug court and they're like, okay, you have a probation officer meeting, you need to walk 6 blocks over there. I mean, so in those 6 blocks are very dangerous, because if I'm walking those 6 blocks, who am I meeting along the way? Who am I seeing along the way? Is there, a liquor store along the way, a pot shop nowadays along the way? So having all that stuff, like our drug court we had a doctor, we had a nurse, we had a social worker. As soon as you get out, you have a social worker. I think she came every 2 weeks. We had, the addictions counselors are there. So there was the probation officer was there. So I didn't have to leave very often, it was just to go home. And then in the evenings we had, NAA, 12-step programming, whatever you wanted to do, that was your choice. But yeah, I really believe that wraparound service was so key, and not having to like try to make it to appointments when you don't have transportation, right? It's very, very cold here in the winter, right? So if you're walking 6-8 blocks, like the odds of me detouring somewhere else is pretty high, especially in those first few months.
Yeah, that's a challenge no one brought up, was transportation, right?
Yeah.
Did you have an easy time getting around to all your appointments, or how did that work?
Well, that's in one of my ideas for like best practices is
Okay.
Toronto DTC provides, they give you food if you need food. If you're coming into the CAMH building, like one of the staff members is going to get you some food, get some food in your belly. There's coffee, there's drinks. If you need food to take home, they have gift cards to provide for you. They also have, I don't think bus tokens anymore because I don't think tokens exist down here anymore, but like they have like money for transportation. And yeah, I think that's like clothing. They offer so many like good things that people need. We have like a place called Gifts of Light, where our peer support worker gets many donations, and you know, if someone needs socks or anything like that, our team there is like right on it, and they get you what you need, which I think is really one of their best practices.
Okay.
Just if I may, jumping off what Megan was saying in the beginning about structure. So for obviously for a lot of people, it is very beneficial. For me, I struggled with it like the entire time. And actually, even after I completed the program, it's only like very recently in the last few months that I finally managed to be on time to places and like to, I don't know, sleep a reasonable amount of time and wake up at all that like normal stuff. And I think so one of the things that is great about these courts is that they treat concurrent disorders. So, you know, if you have ADHD or depression or borderline or whatever it is, that's going to impact how capable you are of doing things that seem normal, even if you're not using. So yeah, so that was very helpful. There is a psychiatrist that you can see, and basically so much is available. So many like mental health professionals are available to you. And of course, it takes time to treat mental illnesses. You may have to try different medications and a variety of other individual differences with that. So hence, it may take a long time, but they are there to assist you with that other massive aspect of your life that is probably also a contributing factor to your addiction, because I think a lot of it is also self-medication, both for trauma and mental health and so on.
Right. Well, congratulations on getting that set up now.
Yeah, apparently it took me going to Europe and like changing the time zone that I was living in, and then coming back. And it was like, wow, now my entire world is finally like aligned with this time zone.
That's awesome. Okay, we should totally go ahead.
Judy, can I add something? She just made me think of something. Also too, like I didn't struggle with this, but I, you know, my partner went to a drug court in Moose Jaw, and he really struggled. He can't read. He's illiterate. He's dyslexic. He has ADHD. He can't sit still, and it was very difficult for him to, you know, do the workbooks, even to sit still and you know, write his smiley in the morning, right? Like we had to do this little check-in thing, and it was very difficult for him. And Judy, you probably remember, because we came down to help out that drug court, and it was, you know, like once I read things to him, like read the questions, and he was able to participate. But yeah, I think that's where the cookie cutter thing don't work, right? Because some people have disabilities where they can't, and maybe they're like, he's ashamed of his, right? So he doesn't like to tell you that he can't read. He doesn't want to tell you that he's dyslexic. He doesn't want to he's been signaled his whole life out for his ADHD, been kicked out of schools, you know, things like that. So he's not going to tell you that. But I think that's where the communication and having a doctor and having a medical team in that can pick up on those things and And so it doesn't have to be announced to the whole program, like to all the other peers that are there, especially if there's a lot of shame being felt already.
Right.
And a lot of trauma from it too.
Okay, we've got about 20 minutes, I think, left. So maybe we should move on to the last piece, which would be the best practices. So let's hear from you guys on what you think drug courts should be doing best practice wise. Go.
I have lots, so I don't know. Do you want me to go first?
Doesn't matter.
Okay, well, I have one of the big things for me is that I felt, this is just a program recommendation, that track 3, I felt like it's the least planned track. I don't know if the other drug courts go by tracks, but we have track 1, we have assessment phase 1, 2, and 3. And I feel like track 3 was such a rush. Okay, here's your extended curfew, you don't have to come to program, kind of goodbye, right? And then the after drug court, right? Like what happens after drug court? I remember my probation officer telling me I was just about to go into track 3, and she said, you're not going to track 3 unless you get a job or go to school. And I already had my grade 12. So, I was like, okay, well, I was taught enough in the first 2 tracks that I knew if I went back to working in the bar and hospitality industry, that I would end up using again, because drugs are so much there. So I knew I had to go to school, but I didn't know what to go to school, and I had no guidance on that. We did have like that work prep place at the time that I went there, but all they did was resume building, and I already had a resume. So I needed more direction with going to school. And so my program recommendation would be kind of like a peer support program, having participants, past graduate participants that are doing well and that are in the workforce, coming back and maybe like a career day and like talking to us or partnering up and saying, I would have loved to hear about how somebody applied to school. How did you get past the barrier of having such a huge gap in your resume? How do you get past the barrier of having a criminal record? Where can you apply? What do you say in a job interview? Going to university, like, do I say I have a disability? Do I, it would have been really nice to have those things. Peer support is so important to me today. I get so much from my peers. And I feel like if I would have had that in track 3, a little bit more from past participants, it would have been, that journey. I ended up taking a business certificate that I have no use for today. I work where I work addictions counseling or, something like that would have been more beneficial to what I do today. But I felt so rushed into going into school. So now I have a huge student loan and I do not use my business certificate for anything.
Okay, good point.
Yeah, I'm just going to say that that's a fantastic idea. Having like more direction and also individualized direction about like work in school, because I feel like they're pretty sort of standard choices, and the assistants, I've been to lots of those like career places, and they're like, okay, do this for your resume, or like, oh, if you're going to apply to university, this is like how you do it, like in concept. And I find it all like really confusing. Plus, like the deadlines for university is like so. Anyway, so yeah, having people come in that could assist you in some way, whether it's just talking or something like a little more direct, that aligns with what you see yourself doing. So yeah, idea.
I think too, a lot of those work prep places, like they don't have criminal records. They don't know what it's like to walk into a university and feel like you have junkie written on your forehead. And so like that was like, I had no confidence. Like I went in, I'm taking accounting and, and I'm getting 90s on my test, yet I felt like I was the biggest idiot in the room. Like I felt so stupid. I felt like I was a junkie that everybody knew. And then I had nobody to, like, I talked to my sponsor about it. I talked to my counselor about it, but nobody really understood because they hadn't, I needed somebody who had gone through this. Like I needed a peer that had the same kind of story as me, who had lived experience and, not just somebody who had gone to university without that, but that didn't feel that way. I don't know if that makes sense, but.
Makes sense. Yes.
Yeah.
Okay,
and then I guess I guess too, just to add to that too, is that even for after, sorry guys, after you graduate, when you're that first year, when I graduated, that first year after is so like, I don't know, like the voice was back in my head telling me I could pick up and no one would know. I'd moved to another city. Like I feel like that's when I needed more support than I did maybe in track 2. But and I feel like there really is nothing for that. And this is where I would like going back to MRT, it would be really cool if we could have that as an option, especially now that I hear that drug court has implemented new books in, and I would love to take those books. However, there's, to do MRT, the people actually have to be, there needs to be 2 people trained, I believe. And so you can't just go and buy the book and do it yourself. Like you have to be in a peer support group. So to have that offered would be amazing. Especially like my sister's kids were apprehended and placed in my care, and I've never had kids before. I don't know what I'm doing. And so when I seen that they have a parenting one, I would have loved to do that.
We'll get you set up, Megan. We can do that.
Okay.
Can I just kind of touch on Megan? I had a different experience with after completing DTC in Toronto. I feel like it's a long-term thing. There's so many programs and stuff that offer like maybe 6 weeks of counseling or therapy. But with DTC in Toronto, like they're there for you for life if you want it. I'm 5 years out of the program, or 4.5 years out of the program, and I still do counseling or therapy every week. And I still go in and visit. And if I wanted to attend like the groups and stuff, like they have like an open door policy. So yeah, that was a very different experience for me here in Toronto. But yeah, I think that's one of their best practices, as well as our GTC program down here. Their slogans, so to speak, is stay connected. And they really follow through with that. If you reach out, someone's always going to get back to you and always going to like try and support you and whatever you need. So
yeah, I just want to agree with Melissa. I had the same experience with Toronto. Like I still talk to them, and I think it's been like 3 years since I've been out of the program. And like I called my therapist from Europe. I was like, I'm depressed. So anyway, yeah, like they're extremely supportive long term, and I really greatly appreciate that.
Yeah, like I know Regina, like we're always welcome back. We can always come pop in. Like I know Judy's always posting pictures of grads popping in. I guess where the confusion is that I moved, right? I moved an hour away. And so it's not as easy for me to go back. So if I knew that there was group programming, then I can make that a part of like a regular thing. Or, like I know one of the treatment centers here, after you leave, they do a Zoom thing. They have a Zoom check-in thing, and they do it at 11 a.m. every morning. So if you can pop on, like I could come today and not come for 2 weeks, right? But I know it's always going to be at 11 a.m. So I think to see something more like that for us guys that do, like, obviously Saskatchewan, we don't have many drug courts. So I'm not even from Regina, yet I had to attend that one. I was arrested in Saskatoon. I'm from Yorkton. There, it wasn't offered in the cities that I resided in at that time. And so I had to go to another city, but when I graduated, then I went to a different place. So, which is the story for quite a few people. So it's how can we stay connected if we're not in Regina?
That's always a challenge, yes.
Yeah.
I like the idea of the Zoom thing though. That would be, it's much easier to like get up and know that you have like a Zoom appointment, or a Zoom, there's like a Zoom meeting at like 10 o'clock, and even if you're not in Regina or whatever, you could still attend. I think that's maybe having more of those, implementing more WebEx or Zoom meetings would be really beneficial to some people.
One good thing that came out of COVID, right? We figured out how to do that. Okay. How about I throw out one last question? You guys can answer it for me. If you were running drug court for a day, what's one thing you'd change? Everybody give me an idea.
too many ideas. Oh my God, which one to focus on? Oh my gosh. Having like specific trauma programs that like not just like rehab and this and that. Like I actually ended up going to the women's inpatient unit. So which is not like somewhere they generally send you. And that was really, really helpful because I met with a psychiatrist once a week. I was there for just 3 weeks. COVID happened, but it gave me the tools to process trauma on my own when I went home. So that was, so not just being trauma informed, but having specific programs that deal with trauma.
Okay, good. Melissa, what would you do if you were boss for the day?
I wouldn't change anything. I'm so biased because they help me so much.
Well, that's
And
good.
like they went above and beyond of like the call of duty, and I'm just like so extremely grateful for them. I think their program is absolutely amazing, and yeah, I wouldn't I'd take the lead from somebody else because they do such a good job. So
Awesome.
yeah.
Megan, you're me for the day. What would you do?
I want to be you for the day. That's why I'm growing my hair out. My thing, I didn't get to talk about this, but the biggest thing that I would do, I love how we smudged in the morning at drug court. But I would like to see more cultural stuff. So I think that I would decolonize the courtroom. I know that we clap, but clapping isn't enough. We have so many people that have lost identity, and you know, with all this talk about stuff, I would like to see decolonized courtrooms and having a cultural liaison that could, you know, work with Indigenous people, because I feel like they, you know, they have to get their identity back. And that, how do we do that? How is that implemented into the treatment process? And I think that the cultural liaison, we were lucky enough to go to sweats. We were lucky enough to do those things. But if we had a cultural liaison that could work with those guys to work on their identity, because that's a major trauma piece that is missing in our drug court right now.
And continuing past graduation too, right? The community supports that you can connect to.
For sure. Yeah.
Okay. Okay, we have 9 minutes left. Oh, sorry, Nicoletta.
Sorry, I was just going to say, can I throw in something really, really quickly?
You sure can.
Okay, great.
9 minutes, go.
A larger focus on like restorative justice practices as well to integrate into specialized courts, so that also like considering different types of sentences or practices that maybe result in no criminal records, or finding other alternatives to either incarceration or whatever form of punishment that, you know, of the day.
Yeah, I 100% agree with Nicoletta. And like, I know that with our drug court, it was a 16-month program. So then there was people that had maybe their charges were only going to be a 6-month sentence, so they weren't able to attend. But if we could just adapt, like we don't want to do cookie cutter, right? So let's adapt the program. So this person's maybe only going to be there for, you know, have like a different area where people with those lighter sentences, and then it could be like an alternate measures, right? Like it could be something where they don't end up with a criminal record after. And it would actually give them more reason to stay, because I know that a lot of people wanted to opt out, right? Like they'll go for 3-4 months, opt out, time served. But if you end up opting out, then you get the record. If you stay till the end, you don't get the record, and that might be enough initiative for people to actually to finish with those smaller sentences.
Okay. Good. Well, thank you very much, ladies. It's been nice spending time with you and meeting you from Toronto. I hope everything goes well, Melissa, with your baby. Let me know when.
Thank you.
Yes.
I'll send you an email.
All right. Thank you. So I don't know if anyone has any specific questions. We have 8 minutes left.
We have 2 questions in the chat.
Oh, okay. Perfect. Thank you.
So I'll do the first and then you can answer, and then I'll do the second. So the first question is, what were the most meaningful incentives for you all? In Guelph, we do gift cards, extending or taking away curfews, skipping a week of court. We're always looking for more ideas.
I can tell you what ours was. We have fish bowls. I don't know if you guys have a fish bowl. So if you had 2 weeks of clean screens, not being late, I don't know, Judy could probably elaborate more on all the details that they did. You got to pick from a fish bowl, and it was like a gift card. It was like things that you said. And that thing that we all wanted was to get lunch with Judy, because it meant she was going to take you out for lunch. And I remember one time I got a gift card and I lied and said I got lunch with Judy, but then they realized. But it was knowing that, you know, it's more than just having a lunch paid for you. It's knowing like somebody, and it would be cool if the judge would do it too, you know, lunch with the judge, right? It's the fact that they would sit down and eat with us and have a conversation with us, that we're equal to them, that we're humans. So it's more than just a free lunch or a gift card.
Just so you know, Megan, it is lunch now with the judge and Judy.
Oh, really?
Yes.
I think I deserve a fishbowl for being on this thing. So maybe I'll get it.
Anyone else want to answer that question? Did you have incentives that work for you?
No, not for me personally. There were no incentives that I was particularly invested in. There was one sanction though that was personally helpful to me, and it was probably like the only one, which is I was given a writing assignment to do, and it took me a very, very long time to actually hand it in, and I came up with zillions of excuses, but that was very helpful to me and much more effective than like a typical sort of authoritarian sanction, because that just always makes me, I don't know, like it repels me and it doesn't make me feel like, I guess, internalizing labels, right? You're being punished. Okay, so you're this sort of person. You're basically, I think just in society, people do what you expect them to do. So if you sanction them, you're expecting that, you know, you've done something bad, we're punishing you. So the person's going to continue that behavior. But yeah, the writing assignment, even though it was a sanction, it didn't feel like it, because it gave me the time to process my own experience, and like, yeah, it just gave me insight into myself and the program.
So we can move on to the second question. Thank you for sharing your experiences and wisdom. I've learned a lot, and there are a number of wonderful ideas on how to improve the system. Is anyone on the panel open to speaking to the healthcare branch of Ontario's Ministry of Solicitor General's staff, healthcare in the jails and remand centers, to share their experiences and recommendations? So this is a comment question in terms of anyone here on the panel wanting to work with this division. I can copy and paste into whomever is willing to take up this.
Yeah,
I'd be happy to.
I'm willing to too, but I don't know if it would make a difference because I'm in Saskatchewan, so I was never incarcerated in Ontario, but I'm definitely, I already speak about the SHA and stuff like that, so.
I would be interested in doing something like that, but like Judy said, I'm having a baby in like 4 days. So if it works with my schedule, I'm totally up for it.
Way to go, girls. Good job. Any others, Lisa?
Nothing else at this time. I'm just asking the person who put forward the question in the chat if they would like to share their information so that everyone can connect.
Okay, perfect. Okay, I think that's us. Good job, everyone. I really learned a lot. I took lots of notes. I was trying to look like I was watching the screen, but I was writing at the same time. I have pages of notes. So because it's all about drug courts getting better, and I can only get better if I hear from people that use the service. So thank you for all your insight.
Can I ask a question quick? Melissa, when you're talking about Toronto, are you talking about Toronto Drug Treatment Court? Is that where you got all your help?
Yeah, Nicoletta and I both Toronto.
Oh, perfect. Oh, great. They're our next event here. And so, I needed to ask that. I wanted to make sure I'm thinking about the right one. That's super. Thank you. Thank you very much for your presentation. You were right on the money about all the lived experience and peer support stuff. That's the same list sort of that we've come up with the hard way through thinking and talking through trial and error. And so if we can see it on the bottom the same from all across the country, and then we can keep passing that message to the people at the top, and they care enough to change it. We got the right recipe. The formula is correct. Thank you, guys.
Thank you for having us.
Well, then I'm going to move on to the Toronto Drug Treatment Court, and we have Sarah Hubbard here. I don't have a bio for Sarah, but Sarah's going to maybe introduce herself for us. Hi, Sarah.
Hi, yes. My name's Sarah Hubbard, and I'm one of the social worker therapists at the Toronto Drug Treatment Court, as well as currently the interim court liaison with the Centre for Addiction and Mental Health in Toronto. I don't know if Jennifer wanted to introduce herself.
So I was just signing out of the last one and signing in. Hi, my name is Jennifer Loft, and I am a Ontario Ministry of the Attorney General Assistant Crown Attorney for a really long time. I'm not going to disclose that, but I have been the only MAG Crown on the Toronto Drug Treatment Court since 2017. So that's coming up to 6 years. I work together with, of course, with the PPSC, and they have a roster of 4 crowns, including our team lead, who is Chris Green, who were the crown portion of the court. So do you just want us to start? We don't.
Let me say, sorry, Jennifer, I didn't see the, I had to take Robin off and put Sarah on, and I missed that there was a second party there. So I apologize for not introducing you, and welcome very much. And yes, please take it away.
Okay. So we're here to talk about the Toronto Drug Treatment Court, which is the first drug treatment court in the country. So we've had gone through a number of iterations since the first one, with Justice Paul Bentley at the helm, and a number of people, all of whom went on to become judges, or so many of them went on to become judges, and that includes, of course, His Honor Justice Kofi Barnes. It includes our own Andre Chamberlain, and now we have as our lead judge Justice Heather Pringle. Sarah Hubbard works as on the treatment team associated with CAMH, and she is the one who appears with us every week in court, and she also has a roster, or she has her own clients for whom she's the clinician. But just in terms of the subject matter for today, the how and why, I think we have a number of things about our court that are maybe different, like certainly different from what might be set up in Saskatchewan, or other parts of the country, where travel to a court is absolutely one of the challenges, and access to the court. But we have a lot of challenges because of our big city setting, and intense, I think, population, and very needy population. But I want to ask, I'm going to turn it over to Sarah for a moment to talk about the how and why, and really the I'm going to call it the evolving how and why of the Toronto Drug Treatment Court.
Yes, thanks, Jennifer. so I don't, it maybe makes sense to start with the why first rather than the how, but Toronto Drug Treatment Court is, I think, unique from most courts in that we are strongly harm reduction based drug court as opposed to an abstinence-based model. And the why of that is out of necessity. Here in Toronto, we, you know, as a lot of other places are also experiencing, we're seeing, you know, the effects of the opioid crisis, the toxicity of the drug supply. A lot of the drugs are poisoned with other substances that are unknown. So in terms of running an abstinence-based court, we're finding because of all of these issues, the individuals that are applying to our program and coming into the program and participating in the program have become much more complex and much sicker, unfortunately. So in terms of mental health wise, we're seeing a lot more individuals who are dealing with issues of psychosis, depression, some more severe mental health issues. I think, you know, from watching the individuals before us who've been through the program, the woman from Regina mentioned, you know, you can't help folks unless they're alive. And so that's sort of really our view that we've had to take here in Toronto is that, you know, we have folks that are using very heavily. And our approach is to keep them alive in order to be able to help them in other ways. In terms of the how, I mean, how we run a harm reduction drug court here, we've, you know, I think we've sort of figured it out as the years have gone on, and particularly with the pandemic, that's sort of pushed it into overgear a little bit. But in terms of, you know, like we provide naloxone kits, naloxone training immediately when people are released from custody. It's something that's addressed in our groups, at least on a monthly basis. We provide harm reduction supplies to all of our folks whenever they're here at CAMH. We also bring them to court for folks. You know, in terms of some of the more core aspects of the program, like urine drug screens, we're not asking for folks to leave screens in order to look for whether or not they're using substances. We frame it to participants in terms of it's an accountability and an honesty piece. So it's, you know, it's part of the program, but it's also just a part of accountability. We ask folks to report their use in court as well. So those things work the same, but for different reasons. We're not looking for abstinence. We're looking for honesty and connection. Also, you know, you know, the reason for harm reduction, there's a lot of different reasons, but one of them is that it opens a much wider sort of entry point for a lot of more folks to enter the program. Folks who are using heavily and are very much in active addiction, the idea of abstinence can be overwhelming. Treatment abstinence is not necessarily going to be on their mind at all, and so it kind of puts up a barrier to accessing treatment. So we sort of take that barrier away with the, you know, ideally the goal that folks will come to that sort of decision on their own, that abstinence may be what they want for their life. But we sort of allow that process to happen autonomously with the individual. We meet the client where they're at in terms of, you know, what are your goals and hopes for coming into this program? That's what I generally ask applicants that I am screening. I make very clear to them, we're not asking you to stop using substances. Abstinence is not a requirement for this program. You do, however, need to have some goals around reducing either your use or reducing the harm of your use. And so generally throw it out to the client of like, what are you hoping to get out of this? And answers that I usually hear are, you know, they can range from like, yeah, I want to stop using to I want to stop overdosing every week. And so that's something we can like really tangibly help with. So yeah, a number of different reasons. And, you know, one thing we've had to do in order to sort of keep the harm reduction model is individualized treatment plans. So that's something that's become very big in our pandemic era particularly, but it's something that's necessarily carried over into the present as well. Because again, folks, substance use is significantly higher, and that's for a number of reasons. These substances out there are stronger, more addictive. They require you to use more frequently to avoid getting sick. The substances they also contain other substances that are not expected that can have mental health implications. So we really sort of individualize everyone's treatment plan in terms of group attendance, whether they're leaving screens on a color system or once a week, how many court attendances, things like that. Currently we do still have a requirement that in order to officially graduate, it does require 3 months of no substance use. However, we do have another alternate category of successful completion. And this would be open to an individual who sort of meets all other requirements of, I think, sort of a standard drug treatment court, other than the abstinence piece, in terms of these individuals may look like somebody who is potentially using, on the weekend only. They're maintaining a job or volunteer or school, and their substance use is no longer, impacting that in any meaningful way. They've reconnected with family. Sort of all other aspects of their lives have drastically improved, and substance use isn't sort of meaningfully impacting that in any way at this point. We are also working towards looking at a sort of an alternative graduation status as well, to sort of integrate that harm reduction model even further into our grad.
Okay, thanks, Sarah. And so that's sort of an outline of where we're going, and we're changing all the time. And if we can move to the barriers that we face in the Toronto Drug Treatment Court, which is of course related. It's almost the same as challenges, not quite. I kind of struggled with that at first. What's the difference between a barrier and a challenge? But definitely in terms of barriers, if I can speak to the barriers from the criminal justice side, I divided barriers into two categories: barriers to eligibility and barriers to application. So barriers to eligibility really focus on the charges that we can accept. And I want all of our partners to understand that it's not a simple matter, and because sometimes we are pushed sometimes by our treatment providers, Sarah, and by duty counsel Aspasia, to accept charges that aren't on the list of ordinarily eligible for drug treatment court. So we try to be open and flexible, but we still have we have to deal with policy which is formed actually at the federal level, and so there are layers of bureaucracy that are involved that we have to pay attention to. And not only that, but there's like the overlapping layer of provincial Crown policy as well that I as the Crown have to pay attention to. So violence is still a no for us. I'll temper that by saying serious violence, and we look at it contextually as well as just like on the page. In other words, was this an offensive violence that may have been committed in what could be interpreted as a defensive way? And I'm thinking about a woman in an abusive relationship, for instance. I'm certainly always alive to that. But also like pushing away a security guard in the midst of a shoplift, a scuffle, further to an arrest, versus predatory violence. I would have to say, for us, predatory violence is a no. Generally, offenses that with weapons with a lot of criminal mental intent are a no. And a history of serious violence can be a barrier to eligibility as well. And that's not just because we as the Crown doesn't want to see, because we don't want to see someone who has a history of violence in our program. We also have to be mindful about all of the other participants in the program and how vulnerable that they might be to persuasion or even bad acts coming from people who have had demonstrated over a period of time a history of significant aggression. We know our therapists can handle it. We know that the court team can handle it, but in terms of the participants, they're entitled to feel safe in their groups and in court too, and so that's something that we take into account. Another current barrier to eligibility is the dropping number of charges. Now that sounds kind of weird because that doesn't sound like a barrier, right? Like, oh, well, isn't that good? No, in this sense, it means that because in Toronto, they very rarely charge, the police very rarely charge possession anymore. And that's again, the evolving policy around criminalization, not just of cannabis, but the sort of the appropriateness or the moral blameworthiness in criminalizing possession of drugs for drug users. So there are a lot of those charges that aren't being laid anymore. A lot of those folks would have been eligible for our program, but they're just simply not being charged. And so they're not entering the criminal justice system. So we have fewer of those to deal with. And the individuals who are charged with drug-related offenses, it tends to be the more serious offenses that cause more concern. Trafficking. Well, is it trafficking? Is it selling for use? Or how about look at all that other stuff? Is there a lot of money involved? Is there equipment? Are there multiple customers and things like that? So that definitely can be a barrier. Now, in terms of barriers to application, well, there are lots of those, and I've heard today quite a lot about some of those barriers. We do have difficulty identifying potential applicants and potential participants. We used to attend police divisions, do a significant amount of outreach at the detention centers, for instance. And I think Melissa Duck mentioned this as well, but people have to know about it at the institution. We have different, so now that throughout the pandemic, the institutions became really locked down, very difficult to penetrate for justice system stakeholders, let alone people who are sort of justice system adjacent, like social workers and so on. So we don't do any of that anymore. There's also difficulty communicating with potential applicants, and that is for duty counsel, defense lawyers, social workers. Most bail matters are now dealt with virtually, and that means that people are brought to court. And now, because of the transition to the new Toronto courthouse, where they've taken 6 courthouses, well, 4 have moved already, but the plan is 6 courthouses are merged together into one giant courthouse. And all of those 6 bail courts have gone up to North York, to 2201 Finch. So they've really separated out the bail matters from the rest of the system. And that is it's already causing us a lot of grief. And that's going to continue to cause us grief, because it's so important when Sarah talks about meeting people where they are, well, you have to meet them. Like, you have to actually meet them in order to determine, willingness to participate in the program, in order to, start off that therapeutic connection. Our people were in the court at Old City Hall twice a week, because we had court twice a week, and they could meet people in the cells twice a week. Just before the pandemic, our court was cut in half, and we were told, okay, you only get 1 day a week. It's only going to be once a week. And so that, we thought that was terrible. But then then the pandemic happened, and then the new courthouse happened, and we don't get them at all. The idea is they'll go to the bail center, and all of those difficulties with communication are in fact completely emphasized. Why does that matter? Because the access to not just a social worker who's associated with a drug treatment court, but also specialized duty counsel who would be available to explain the process of drug treatment court to sort of promising applicants or people who showed an interest. The pandemic happened to coincide with a protocol shift that happened to coincide with a policy shift. So all of that is making it very hard for us as we and to keep open the lines of communication that we need to operate as a program and as a team. Do you agree, Sarah?
Yeah, very much. I mean, there's a number of barriers that the new courthouse is posing at the moment, and likely will continue to pose. I mean, in terms of the bail center alone, it really sort of undercuts our harm reduction and safety policies for us, because when somebody gets out of custody, it's generally when they're at highest risk for overdose. Their tolerance, unless they're on opiate replacement, even if they are, a lot of folks are still using on top of opiate replacement before they go into custody. When they're released from custody, their tolerance is very, very low. As we've heard from other participants who previously graduated the program, often your first instinct is to go and use substances. One of the sort of main safety pieces for treatment is to meet individuals like as they are getting out of custody. Here's your naloxone. Do you need a refresher on how to use naloxone? You know, here, you know, be reminded of the opioid overdose prevention strategies. Don't use alone. Do a test dose, like all of these sort of safety protocols. So a lot of the sort of higher up decisions that are being made are sort of not necessarily taking into account the ground level functioning of DTC and just sort of basic safety, keeping people alive and with us for sure.
And that's, I mean, as I said earlier, I thought it was, you know, barriers and challenges are so closely related, because these are, you know, barriers to eligibility, barriers to even being able to apply, then turn into challenges in keeping it going. So, and when you remove, when you take away a lot of the things that we've been relying on, one of them being a structure that it is very hard to get used to for most of our participants, I have to say. And we have noticed that when a therapist leaves, for instance, whether to take on another job or maternity leave, that's a period of transition. And there has to be a readjustment to everything that goes along, and because everything is happening right now kind of at the same time, and we're just not sure exactly, honestly, where exactly it's coming from, this push for it's a policy shift to broaden the expertise of judges, crowns, duty counsel in the system, and the idea behind it is that everybody should be able to do everything. But what is going to be a challenge for us is to maintain our program in the face of this. Like, how do we, when we know how difficult it is to change anything? So we're going to be moving to the new courthouse. So that's a big challenge. Okay, and our first drug treatment court in the new courthouse is going to be Tuesday, the first Tuesday in May. So that's going to be, or the first Tuesday in, what is it? Anyway, I probably have like a big black mark in my book. But we're out of Old City Hall on May the 28th, and on May the 30th, we'll be at the new Toronto courthouse. Okay, and there's a beautiful new courtroom that is like all new and swishy and everything, but the pieces that really make a team are still a little bit up in the air, and we're concerned about that. And I think it goes without saying that because of bail courts being hived out of the regular court, and we still have our bail court at Old City Hall right now, but we're going to lose that with the move to the new courthouse at the end of May. People will be spending more time in jail, and in circumstances where they are, probably at risk. So we will be looking for ways to deal with that. We will be looking for ways to open the communication. We're looking for ways to maintain consistency in the context of the new landscape. I think that's going to be hard. Another thing that is a challenge from a justice perspective is the overwhelming backlog that has that COVID brought about. And I know in the last panel they said, well, that's one good thing that came out of COVID, and it's true, because you know the capacity to have virtual courts has made some of what we do better and more available and more accessible. But on the other hand, I think we all know what happened at the onset of the pandemic. First, Toronto Drug Treatment Court, it was lucky because we got going long before most of the other drug treatment courts in the province. And I don't know about the rest of the country, but at first it was completely canceled for months. And we were kind of operating on an ad hoc basis on the phone. It's almost impossible to believe, but there we were, like on the phone from police divisions, cobbling together the team, basically doing what we had to make this happen. And then we started court again once a week instead of our what had been before twice a week. And there was a massive adjustment required, and that's going to be that's going to continue to be the case. But because of the justice backlog, there's been a lot of there's been a huge push to get charges out of the system. So that means that a lot of people who might have been eligible before and interested and maybe great participants and maybe have a chance at stopping the the turnstile of offending aren't coming to us because they're getting kind of screened out or hived off before they even have a chance to think about it. And that as a court for primarily non-violent property offenders, well, those are the first charges to go, right? So those are getting kind of dealt with in other ways, and so the incentive to participate in drug treatment court, I think, isn't what it once was. It's hard. Drug treatment court is hard. It's a lot of work, and as it must be, because sometimes I think that people forget what the ultimate goal is. Of course, the ultimate goal is to improve, for people to recover their lives. But from a justice, from a Crown perspective, is to stop the cycle of offending. And there's just been a lot of turnstiling that's been going on. Multiple releases, very little changing, and some of those people would have been good participants for drug treatment court, but we've had no way to kind of engage them, and also maybe no reason for them to be engaged because they're just released again, and and non-custodial sentences focus on getting people out of jail, especially at the beginning of the pandemic. So that continues to be challenging for us. Like, people sitting out there wondering, is it worth it? This is a lot.
And from a treatment perspective, sort of a lot of the things that Jennifer touched on, particularly around the new sort of model that's going to be implemented in the new courthouse of sort of not having specialty crowns or necessarily a dedicated drug treatment court team in terms of the court side of things. From a treatment perspective, that's pretty concerning for us. Folks know that who are involved in drug treatment courts, one of the sort of main best practices, core principles, is having that continuity for participants for a number of reasons. And one is just it's just basic trauma informed care, to have sort of the same continuity of individuals. Clients that come into this program have enormous trauma histories, have tremendous amount of difficulty sort of trusting authority figures, often for very legitimate reasons. They have, traumatic experiences in court with legal professionals. Some clients, some things that have been said to them by judges in court have sort of shaped years of their life. They've internalized these words. So, not having a dedicated team who knows the participants, who is trained in drug treatment court and trauma-informed care, I think it's going to be a significant barrier coming up in terms of having our clients being able to trust coming to court. It's one thing to trust the treatment team, and the way it's been is, come to court. It's a special kind of court. These folks really care about you. It's going to be a different experience. But we won't really be able to sort of promise that anymore if it's going to be sort of a rotating, like I, as the court liaison, may not know who the Crown will be that week. They may not know any of our participants, or they may have not been in drug treatment court for several weeks or months, have no idea sort of the continuity of what's been going on in somebody's life, their circumstances. And for a lot of folks, all it takes is a look or a tone of voice that's appears to be threatening, even though it may not have any intent in terms of the judge or the Crown that is speaking. Our folks can be sort of very emotionally intuitive, and they can sort of perceive when a judge or a Crown who's speaking to them is actually invested in them, if they actually care about what's going on, versus somebody who's sort of, yep, next, please tell me about use, next. And those experiences can actually be very traumatic for folks. And my concern is that this will pose a big barrier in terms of having people return to court and ultimately stay in the program.
Yeah, Aspasia, are you there? I see you on my screen. I'm just wondering if you're actually there, and if you, because I'm pretty sure that from a defense perspective, because we don't have defense represented on our panel right now, but I'm very concerned about duty counsel in particular, who develop a really important and consistent relationship with the participants, to the extent that even when duty counsel, like the few duty counsel that there are who are trained, when they move off to another cycle, some of the participants will go back to that duty counsel for the final advice, and that duty counsel will appear on the final sentencing or at graduation, and it's just it could represent the loss of a really important cohesiveness on the team. And together with, we've talked a little bit about confidential information as well, but because there is a lot of our participants have had traumatic histories, of course, as Nicoletta said, probably all of them. And there's a limited number of people that they should have to share that information with. So that is also a concern. So it sort of has the prospect of becoming a little bit more of an arm's length justice system situation from the court team, like Crown and Defense, and that is definitely of concern to us. But that's depressing. So just turning to the successes, and I think folks who are listening to the presentations today must be, I'm so proud that two of our recent graduates, Nicoletta Curson and Melissa Duck, appeared on the panel before, and that's really all I need to say about successes, and just really is a fantastic thing, and they've both done so well, and it's just it just is exactly what can happen with the with drug treatment court. It's mind-blowing, really. It's incredible.
Yeah, from a treatment perspective, I mean, it's always great to hear our grads go on and speak about their experiences and just kind of share with everyone how well they're doing. Because this program is a tremendous amount of work. We're basically asking folks to change their entire lives, their way of being in the world, their way of thinking about themselves and others. It's a complete overhaul, and it's not easy. Sort of listening to some of our previous grads talking about successes and best practices. You know, I sort of have my own list of success and best practice in my head of sort of what we're doing right in the program. But it was nice to hear some of that echoed back to us in terms of, you know, like our as Melissa had mentioned, I think, you know, our slogan here is stay connected. We even joke it's, you know, DTC for life. Our main sort of underlying tenet of this program is connection and community. It's a sense of community. So folks, you know, are never, you know, when folks get anxious about graduating, we tell them, you know, this nothing will change except you don't have to go to court anymore. If you want to come to groups, you can come to group. If you want to see your therapist, you can see your therapist. You're welcome anytime. So that connection piece, and I think one way we're able to do that connection piece so well initially is we sort of operate we're very fortunate to have a lot of resources, both being here in Toronto, being, you know, with CAMH, and as well as having sort of private not-for-profit agencies that provide funding and different things, that we're able to provide like a one-stop shop for folks. So, you know, they come out of custody, they come see us at CAMH. Are you hungry? Do you need food? Do you need clothing? Do you need a winter coat or winter boots? It's been snowing since you went into custody. You know, are you on OW or ODSP? Let's get that done today so you can have some money in your pocket. Do you need issues with housing? You know, we have housing partnerships both for temporary transitional housing as well as permanent supportive housing. So we built those partnerships. So sort of all the social determinants of health that, you know, make for a success, you know, and really help folks sort of get on their way. We have built those connections over the years to be able to provide a lot of that. And so I think, you know, we also have an amazing peer support worker who is able to greet folks when they come into the program. And so people really feel welcome here. You know, one of the things that sort of I find kind of points to we're on the right track is that when we have folks that are even, you know, expelled from the program, let's say they brought in ineligible charges and had to exit and be sentenced outside, we have those folks come back to us. You know, they serve their sentence and they go back to the regular system. And as soon as they're discharged, hey guys, I'm out. You know, we provide them a meal, clothes. So seeing the folks who, you know, who were quote unquote not successful in the program still stay connected to us is a big indicator for us that we've sort of been successful in our endeavor in at least some ways of addressing some of those social determinants of health.
Well, and we're sort of learning, and everybody's learning all the time, but we're learning about different measures of success too. And a really important measure of success from the prosecutor's perspective, not the human perspective, but I'm also a prosecutor, is no more charges, like no more charges. The offending stops. It takes time. And this is something that, and I know Nicoletta talked about that too. And from that initial period where there could be a lot of reluctance and, but the sort of prospect of getting out of jail is strong. Like the extrinsic motivator is getting out of jail at the beginning. But then the idea is that it changes over time. And then if the offending stops, as far as I'm concerned, that's the prosecution's success. And we currently have, you know, the graduation is also a sentencing where we deal with the formal sentencing of the charges. And I find that it often seems so strange to be talking about the criminal conduct when the person who's standing before us as a graduate bears very little resemblance to the person who was arrested and charged with those offenses. So that's something that we might want to think about down the line, and sort of moving on to sort of best practices and recommendations. Like, do we want to separate that and maybe not have the sentencing as part of the graduation, because it seems odd, and kind of, you know, it's a reminder of how far a participant has come. But I think we're coming to the end of our time, Sarah, but my final message, and then I'm going to let you have a final word, is something that I've heard over and over again during the presentations today and yesterday, and certainly in the literature, and even in my own practice, which is, as I said, been for many, many years, the importance of consistency. And so that's what we are hoping for in this time of great transition.
Yeah, and just, you know, in terms of treatments perspective, I'm always going to be putting a plug in for harm reduction programs. I know it's sort of a politically charged topic, especially these days. But you know, it's a big adjustment to make, especially when you're coming from a criminal justice point of view and an abstinence-based models. And you know, you've got a lot of folks who are very interested in 12-step programming, and that's absolutely great. But some folks really need harm reduction in order to stay alive. And that's sort of the population group that we are seeing here in Toronto. And I'm just really pleased and proud that we've been able to make that work to the best of our abilities. And we're continuing to try to better our best practices.
And I just took a peek at the questions, and I see that a question someone asked about probation. Yes, we have a dedicated probation officer. That's a really important part of our court team, and again, consistency, and who develops generally a really close relationship with participants. Helps a lot, because many people come in on probation and all of them leave on probation. So it's really important.
I do see a question here saying, being such a large population you're dealing with, does your DTC have any experience with individuals with developmental disabilities? If so, do you find there are different methods of success with these participants? Absolutely. And you know, we do have some individuals with significant development disabilities, and it's been an enormous challenge. It's something that we've seen in treatment is actually an enormous gap in the system in terms of individuals with developmental disabilities and the justice system. They don't quite fit into sort of any of the therapeutic courts or you know, alternatives, and yet they need that support. We've had to, this is sort of where our individualized treatment plans have really been helpful. And we've been lucky to have a dedicated court team who cares about our participants and was willing to sort of work with us and work with the individual to find a solution that, you know, didn't look like a typical success. But, you know, the person was, you know, this individual I'm thinking of has been housed for the first time in his entire adult life. He has multiple supports, and although the individual maybe not in the program anymore, you know, they continue to seek support from us. But yes, it's an enormous gap that we've personally, that treatment has identified, that there doesn't even just be a lot of research on sort of developmental disabilities and the justice system. So hopefully something for future. And do you allow clients to keep attending if they don't graduate or out of the program? Yes, absolutely. So again, it's sort of, you know, our motto is connection. One might think that, you know, that becomes an untenable situation if you're from a treatment perspective. Yes, our sort of unofficial caseloads can get quite large, but that's sort of one of our core tenets of this program is stay connected. If you need support, we are here. I think it really depends on the individual in terms of allowing them back to groups. It's sort of a one-on-one basis. Depending on the circumstances of their exit and different things like that. But generally, to the best of our ability, while keeping our participants safe and comfortable, we do try to welcome back folks who have exited in a non-graduation way and keep supporting them individually in the community or through individual counseling if need be.
Okay.
2 more questions, I think.
2 more questions? Okay.
Does the court ever make detox orders?
Well, I mean, I don't know if we formally call them detox orders, but yes, we have made going to detox a condition of continuing to participate in the program. It's like it's tricky area, but that's kind of how we do it, and we rely heavily on treatment to kind of put it in a way that makes it seem irresistible. Going to detox, like
yes,
the
I mean,
alternative might be bail revocation, for instance.
Yeah, I mean, if we see individuals, who are struggling and they are looking at sanctions, treatment may recommend, you know, why don't we propose to this individual that, you know, attending detox won't hurt their situation in terms of sanctions. But I don't think, not in the recent years anyway, have we had people formally, you know, ordered or mandated to attend detox.
And I think there's another question about coming. Anyone who has ever once been, yes, anyone can, yes, please come back.
So from the treatment perspective,
yeah,
yes, it's not that they are formally brought back into the program.
Right,
it's not
right.
like a legal revolving door of anyone who's ever been here. That being said, you know, we do have folks who were with us, like a lot of our individuals are with us for years in this program. And so we have folks that exited the program 10 years ago who show up and they want to see their therapist from 10 years ago. Hey, I wanted to show you I'm doing really well now. Or, hey, I'm really struggling. I haven't, you know, been here, seen you folks in 4 years, but I'm wondering if you could help me do a residential treatment application. So it's not like we take them back fully into the program and they're allowed to do groups and all of that, but we do what we can in terms of how can we help? Can we get you connected to a residential treatment application? Can we, you know, what can we do in terms of helping support you sort of in the program, but not in the program?
And I mean, we have had people apply for a second time as well, who've been through the program and they come in again. That's happened too. So it's not a bar to participating again if you need it.
I think it's just a last comment. It would be very helpful if the respective teams could shadow each other on the job. That's a great idea. This way they will get a better understanding of the challenges, difficulties, and strengths possible to get a better multidisciplinary support for clients. I mean, I'm lucky enough as the court liaison to actually have that opportunity to some extent, because I do sort of participate in the court meetings and I'm there in court weekly. But it would be very interesting to have a member of the court team shadow the treatment team. Might cause some ethical and confidentiality issues, being that we do try to sort of keep, from treatment's perspective, sanctions never come from us. Sanctions come from the court team. So we can sort of use them as our bad guy when needed in terms of external motivation. So we do try to keep clear those boundaries of treatment's here for you. The court team cares, and you know, they have their mandates as well. So it might get complicated, but it would be very interesting to try.
Great idea. Our time is up.
Sarah and Jennifer, can I thank you very much for an incredible show of what the Toronto Drug Treatment Court's all about, and life downtown Toronto for my peers and you guys in your wonderful professions. Jennifer said the words mind-blowing and incredible, And that says a lot about what Jennifer was presenting today in her heart and soul about the drug treatment program. And Sarah said connections and community, and that goes to relationship and healing and the treatment that you guys are doing. I was there 40 years ago, going to the old Toronto court, the city hall court, and I overdosed at the end of my 8 years on the streets of Toronto, and Addiction Research Foundation. So CAMH is building there. They had a crash unit that was designed to help keep overdoses alive. And they kept me alive, and that was my partner died. I got home to and sound, and I've been making it. 30 years of sobriety and 40 years because of super counselors that you guys have passed me off to, and it was a blind counselor from Addiction Research Foundation that treated me on the streets that I got to see. So you guys are keeping up the great work of a lot of warriors from the past, and thank you so much for being here today and doing what you're doing out there in the field.
You're welcome. My pleasure. And a major shout out to Sarah Hubbard for participating in the panel with 4 hours of notice. Maybe 3, I don't know, not a lot. Anyway, thank you, Sarah.
My pleasure. It's
I knew
always
she'd
my
do a
pleasure
great
to
job.
speak about this program and our folks that work so hard. Yeah.
You did fantastic. For anybody that wants to see the next presentation, if you go to your link this morning that you were sent, it will have a special link for the 3:40 presentation this afternoon. It's a pre-recorded presentation. Everybody have a great, wonderful rest of your day, and thank you very much for participating.